I may pardon to make a mention, my lord. Please give us.
I would say petition may I make a mention from the list. It's that Land Council Mr. Samantha is appearing for the state I had informed. Item 8. I need to collect some documents and in the meanwhile I have some personal.
No, item number 8 cannot be adjourned. This is old matter.
But only on the last date.
We can adjourn the old matters only if you permit us to vacate the interim orders.
No, here there is no interim order.
Then we can.
There is an interim order, if I'm not
We
mistaken.
will see.
Regular?
But the only difficulty on the last occasion is
Whenever you want. Whenever you want.
I pray for 2 weeks time.
How much?
2 weeks time.
As requested on behalf.
There is an interim order.
This matter on 3 weeks of interim order, if any, stands vacated.
I may be pardoned, my lord. The item 46, my lord, on consideration of my lord's.
No, I was mistaken, my lord.
Maybe that is the only
Well, it's a
condition.
old transport bill.
No, sorry, this is impermissible. See, all matters which required adjudication have not been taken up by this court. These matters, old matters are pending because of
Only on
that.
the last occasion, the Land State Council said, I don't want to file a reply. So, my lord, thereafter, my lord, your lordship referred the matter to today.
Sorry,
And,
sorry, please don't embarrass us.
will your lordship grant a short deferment instead of
Whatever. Interim order shall not continue.
My lord, I may be pardoned, my lord. In item 46, keeping in view the exigency of the matter, my lords have been pleased to allow my memo yesterday and the matter placed at 46 may kindly be taken up today, my lord.
We will take up your matter. Who is for the other side?
My lord, actually, in fact, the State Council has already filed the counter affidavit that is very relevant.
Who is for the other side?
My lord, Senior Counsel, Mr. Buddhadev Rautrai.
So he will have to be informed. Please request him to. Please have his consent. Then only we can take up the matter. We are ready to take up your matter.
My lords.
All right.
By which time?
Mr. Counsel, please inform him.
My lord. My lord.
Please inform him if he is ready. Just give us a time when we can take up your matter. We will take up your matter.
My lord. My lord. Obliged.
Lordship, I want to make a mention, my lord. I have given the memo, my lord, on that CRL criminal appeal, my lord. There are the 3 appellant, my lord. Petitioner number 1 is the son, 2 is the father, and 3 is the mother, my lord. On 3rd September, petitioner appellant number 3 father died, my lord. He is the only son, my lord. I am filing IA for interim bail, my lord.
Why are you making a mention here?
Lord, so difficulty is that earlier one IA was disposed of by retired Justice, Honorable Justice C.R. Das, my lord, along with the madam.
All right, we will see. You are not required to mention here. We will see.
Fine. File the memo, my lord.
You file a memo, also mention before the deputy registrar, so that.
Yesterday I already mentioned, my lord.
Item number 1.
Leave off your lordship, my lords. This is a case, the other occasion, my lords, I was, with leave of your lordship, I was placing, though under the prayer of seeking adjournment. Here, my lords, a land was allotted in my favor, leased out in my favor for having a hotel, star hotel, to promote hotel management as well as the classes of management classes. That was in the year 2008 and registration was made in 2009. Then, my lords, I couldn't raise constructions as desired, as was covenanted in the instrument, my lords. And hence there was an order of revoking my lease, and thereafter your lordship was pleased to protect me. In the meantime, in 2017, pursuant to certain communications interstate, the ZA department suggested that you have to withdraw the writ petition and you pay certain amount of performance guarantee so as to facilitate the process of revocation of the cancellation as well as construction of the hotel industry on the list of the miles block. Then I was not in a position to pay the amount that was fixed by the government, that is 2 crores per acre, so around 15 crores. And pursuant to that intimation, I suggested that I would be paying or I would be managing to make a payment of 1 crore, since that was in the 2 years thereafter, the COVID had come in and my financial conditions was on a compromising mode. Then the state government, the GA department decided you pay 40% of the IPR rate of the Bhubaneswar area as was prevailing, that would be 3.78 crores. So this is where I stand, and I have when this pendency, during pendency of the writ petition, these are the developments. Now, my humble submission before this honorable court would be by 2021 only, the claim of 3.78 crores had come up from the GA department. That is beyond the scope of the agreement. I am not on that. This is a prerogative of the government, whether they can. The only grievance that I can raise before this honorable court to the extent is that 3.78 crores would be paid as a performance guarantee. There was no clauses or no agreement to that effect though. So that is what is staring at me, because that money would be hoarding, but rather it would be a hoarded amount. And I am not a fly-by operator because my credence is above board, and I am not going away or leaving the project as it is, and my credentials are with the state government. So my suggestions with the state government is let me be allowed to deposit 1 crore and start my constructions. Another bottleneck is there that the Bhubaneswar Municipal Corporation, during this pendency of the writ petition or during this interregnum, had allowed some fish vendors to sit in front of the entrance of the hotel. The other day, my learned friend suggested that the hotel face to the national highway. I did make a personal visit. It is not on the national highway, rather it is a service road is going beyond the national highway, and the service road gives an entrance to the landed property or demised land. So that frontage is totally, I cannot say encroached, but they have been temporarily allowed by the authorities for some fish vendors. They have been occupying the entrance. That is my one grievance before lordship. If that has to be removed, then my heavy vehicles can ply into the demised land and can start construction. I'm ready and willing to start construction.
No, that is not the see. You are ready, he is not ready. There is some dispute between you and.
No,
finally,
state government is ready.
See, we have to decide. We will decide on merits. All right, irrespective of what offer has been made by the government and whether that is acceptable by you or not. So we will decide.
So my small point before lordship.
No small point. We will go through your pleadings. We will decide.
No.
This is 2012 matter.
Yes.
2000 for 12 years it has remained pending. We will decide whatever. May go in your favor, may go in his favor. Based on your rights. And
How do you say your credentials are above board? You have not been able to.
Since
No, ma'am.
18 years.
Yes,
You are
no.
established hotel chain or what?
No, by virtue
Yes or no?
that is the status quo. I'm
No,
ready.
forget about status quo.
Ma'am.
You are established hotel chain. You have other hotels.
Yes,
Where?
yes. In India, there are 21 units. And they have been running. And nowhere there is any complaints.
You have 12 years.
My lords?
You have 12 years.
No, this 12 years is my lords because in 21 only, I got my plans approved.
Okay.
And in 21, this amount of money was floated
No,
from
you
the.
got your plans approved means did they refuse to approve your plans? Had you given it earlier in 2013 or 14?
Yes, yes.
You can't be. They couldn't have started
No, there were.
9 years.
Yes. The only question is, my lords, our plan was there and they got it approved in 2020. That is one, the government says that I could have gone ahead with the deeming clause. That I didn't. The deeming clause is there. If my plan doesn't get approved, then I have to go to the authorities and get that approved. Now, if you are
not interested, you leave it.
No, we are interested, my
No,
lords, your lordship.
they have to protect the interest. So if you are agreeable, or even if you are not agreeable,
No, because since, my lords, I have invested, I have already paid 3.5 crores. Since I have invested, there is no going back. I will pay, my lords. And I undertake that I will be paid. So I cannot go back.
We don't know.
And that is, the other day your lordship had suggested, and with your lordship's leave, I personally visited the demised land site and
we'd asked you to visit the site for what?
my lords,
We'd asked you to visit the site.
no. Your lordship asked whether I am ready to pay or not. It is,
See, you
yes.
should
Otherwise,
not have visited the site. You are
Yes.
counsel for your client.
your lordship decided if my client decides to pay, then it is between me and the GA department. So your lordship has nothing to do. But yes, I will be paying, but
We don't know. You have not come out with a definite offer of saying I will be paying subject to decision, subject to what.
no, that
There are so
offer
many
also I have not
conditions.
paid.
So
That offer I am not giving also. I don't have any choice, my lords, because the state government has decided to take 3.78 crores from me. I am only praying before this lordship since my offer is 1 crore with them, and that has not yet been decided. So I can't have a choice. I can only have a prayer.
As you wish.
And otherwise also I am ready and willing.
If you don't, we will decide.
Have you paid anything to the state government after they asked you to make payment? Nothing.
No.
Okay.
I will pay, your lordship. will
No,
No, as your
will.
lordship
There is
is
no
not
question.
pay. We
of
will pay, we will pay.
Will.
Your lordship can take my undertaking, we will pay. Because that point, this during pendency of this petition, this suggestion came out in 2021.
No, but will they accept 3.78 now? 3.78 offer was in 2021.
Yes. During pendency of this.
Yes.
3
But
years have
now,
elapsed.
after in 2024, better you leave it.
No, we are paying balance.
No. Better you leave and approach the state government, better for you.
Otherwise, 3.78, that offer was in 2021.
They still
You are
insist
saying
on
in
it.
2024
No, they
that all
still-
right, that
they
was the
still
offer,
insist
but
on
I'll
it.
pay
They
1
still
crore.
insist on it.
So you are doing
They-
a kind of
my lord,
bargaining
sir,
in the court
They
proceeding.
don't have revised. They have not revised. They still insist on 3.78. Your lordship may decide, your lordship may direct, I will pay 3.78.
Why shall we decide? They will decide.
So let
How
me
much
pay,
amount?
let me pay and come before your lordship. Let this writ petition be pending. I will pay before to this GA department.
Yes, do you have any instructions?
No, sir, I don't have any instruction because lordship last occasion directed him to approach. Because we have given clear terms, you pay, withdraw the application, we will accept. He is not doing anything since 2021. This affidavit was
I
filed since
will
2021.
approach them, your lordship. I
No,
will
if
approach
they are
them, I
saying
will
you
pay them.
Then they will consider.
He is
So why
not paying,
doing that?
not
No,
doing
not
anything,
paying.
and lords coming to this.
No, we will decide it.
My lords, give me 10 days time, I will approach them.
Pay.
I will pay them.
And the present cost of the land is 53 crores, lords.
No, that is
No,
true,
that is
but
there. You
I will
yourself
approach and
have-
pay them. So where is the?
You may demand more, and this is not the manner in which you can spot over a land.
My lord, your lordship fixes it up to 10 days after, I will.
Not 10 days after. It will come on next Thursday.
Yes.
If you, in the meanwhile, you may go to them and get the issue resolved. We will not. We have a duty to decide, not to.
True, my lord.
are not-
Your lordship calls it on
12.
12th. If I beg your lordship's one or within time, if your lordship can be pleased to call it on
Oh.
17th,
Who will, no, sorry. Who will decide? Who
The
will
GA
determine the amount?
GA department.
J department.
GS department, principal secretary,
Yes, sir.
Yes,
additional,
Yes.
additional chief
No,
secretary.
but the lordship, secretary J department will decide what because it's a land matter, so.
opposite party number 1.
List this matter as requested on behalf of the petitioner. List this matter on next Thursday. Stop. Meanwhile, the petitioner shall be at liberty to deposit the entire amount as may be determined by the GA department against what?
Yes, performance guarantee.
Against performance guarantee?
Yes.
Against
They call it, my lords, bank guarantee or purpose.
bank guarantee / performance guarantee. So stop. It has been brought to our notice that in 2021, the petitioner was asked to deposit a sum of rupees 3.78 crores against bank guarantee / performance guarantee by the GA department, which he did not, which he did not deposit. The Land Counsel for the petitioner states that the petitioner is ready to pay the said amount of rupees 3.78 crores. So stop.
One thing in 2024, we have filed an affidavit with your lordship pursuant to lordship direction that we demanded rupees 2 crores per acre, the land allotted to him, and for age performance guarantee loss. The offer was in 2021 3 lakh summer, but if your lordship, I filed an affidavit in 24 only, pursuant to lordship direction.
Yes.
On 25/4,
Where is that?
25/4/2024,
So that has been reduced to 3.7.
In 24 only, 25th of April 24, I filed that affidavit. People also come to that affidavit.
There is no
page 6.
affidavit.
OP1.
Yes. And the affidavit has been sworn in by Srimati Iti Sri Rao.
Just a minute.
That has been modified.
No, what you saying?
They have withdrawn that.
24.
They have withdrawn that, and then pursuant to that, they have decided 40% of the IPR rate. That was under consideration and withdrawn. Thereafter, annexed, your lordship says.
So that is the last affidavit I have filed with your lordship.
And
Please
thereafter,
give a
they have
copy, we
reduced.
can't file that affidavit. 148. Not there.
Page 148. Page 1.
Page 140, no, page 140.
What is the
Wakalatnama and
digital
everything.
page?
Your lordship sees page 102 rather. That was a decision. Thereafter, they have modified it. Page 102. Your lordships, your lordships can produce. Annexer
Give the file.
13, page 101, and then the relevant page is 102.
Consolidated section.
2024, you filed an affidavit.
Yeah, filed an affidavit, so also an application for vacation of the stay because since 2012, status quo order is not continuing. I had filed that application for vacation of stay, my lord.
See the cause title, there is nothing.
No,
Now
it is
vacation
there
of stay is there,
last.
6764.
Yes, ma'am.
So 67.
Prior to that date, I filed that affidavit.
Very strange. 6764 mil gaya. So maybe the affidavit may be behind.
The reply on behalf of the opposite party.
Yes.
That is the reply.
No reply.
No, no, what is
that
it
reply or affidavit?
captioned as?
No, I filed a styled it as additional counter affidavit on behalf of OP number 1 and 2. I've got the hard copies not with me. It was e-filed on your 25/4/2024, e-filed.
And this IA was physically filed probably.
Yes,
That is why it's there on record. The other one is not there on
No,
record. Yes, it is. E-filed hella tha, it will not come on record. It will remain E. Acha, there. Ah, yes. This is there. Why is it not? It is 2022. 25th November 2022. Nah, sorry.
no,
Saying April.
24 minutes. 14/5/2024, I filed an application.
E-filed means it has remained E.
I'll file this. I've got the hard copies. I can give the hard copies. Also.
It was demanded in the year 2021. So, without commenting upon the amount which was required to be paid by petitioner in 2021, we adjourned the matter to Monday. So in the meanwhile, the petitioner shall approach Thursday. With that.
In paragraph 4, we have stated, you return the application, pay.
This is the original
Yes,
copy. Have you
additional
actually filed?
counter.
So,
E-file, you'll also see a pencil mark on the top. E-filed on 25th.
So where it has
pencil
come?
mark is
Yes,
sufficient.
yes, office will never give a. I will give the hard copies to lordship because I've got extra copies. I will give the hard copies just now.
It's not there. Original bookmark doesn't are there. It is there. Right.
Thursday to be listed as the first case. So, by the petitioner shall be at liberty to approach the GA department to seek a fresh offer for payment of the or depositing bank guarantee as performance guarantee which was fixed at 3.78 crore in the year 2021, which was required to be submitted within 30 days from the date of communication of revocation of the order by the GA department. So stop. If the petitioner fails to pay the amount so determined/redetermined by the GA department, the court shall shall decide the matter on its own merits based on the pleadings and other materials available on the court. The court expects that if the petitioner approaches the GA department by tomorrow, the competent authority under the GA department will expedite a redetermination of the amount payable by the redetermination of bank guarantee plus bank guarantee by way of performance security to be submitted by the petitioner. Yes.
May Lordship be pleased to add more one line. It was 3.78 crores in 21, but 24 we had asked him to deposit 2 crores per acre, Milords.
Therefore,
No.
see, just a minute. 1.25 was the rate in 2024, 21. And therefore you were directed to pay 3.78.
No.
So that was the rate. The 3.78 is not just an amount. It is based on the rate of 1.25. So present will depend on the appreciation also of the value and appreciation of the land, and then
And total land allotted is 7 acres, 45 decimals. So it will come to 15 crores, Milords, for trans guarantee as per the 24 offer, Milords.
whatever.
But paragraph 14 you have said prevailing rating 1.25 crores. We have settled at a very reasonable rate, 40%.
40%. That is not IPR rate, Milords.
Right.
That is the affidavit filed, Milords, for vacation of stay. We have stated
No,
that.
that is your affidavit.
Yes, Milords. On
affidavit.
affidavit we have stated that.
So you have said bank guarantee as performance guarantee,
Yes, Milords.
40% of IPR rate.
Yes.
So 40% of the IPR rate, 1.25 crores.
Yes.
That also is not complying, Milords, since 2020.
No, exactly. That is why we have
We will
kept.
see.
You have not stated that it has risen.
Let the office, huh?
But why have they not done?
Let the,
Because 10 minutes
let the
registry.
registry duly paginates the
Bookmark.
brief and sign bookmark
Yes.
and bookmark the brief. Sign bookmark.
Digital bookmark. Digital bookmark.
Lordship, it's a
And do
12th.
digital bookmarking of the
12th.
12th. First case.
Grateful.
Item number 2.
Till then, my lords, my protection may be.
Till then, yes.
Grateful.
My pleasure. This is a application for a restoration of second appeal serial number 4359 and where only 27 days delay has been made. So my prayer is that it should be restored.
What is this?
For this,
Cause serial number 4539 or JC 4359?
essay number.
SL number is nothing.
And that is another 2 petitions for subscription of the appellate number 1. That is petition miscase number 31 and
When was
32.
your second appeal dismissed?
My lord,
This application has been filed for restoration of what?
serial number 43 by 59.
What is serial
43
number
59 by 2002.
What is this serial number?
The serial number, those days there was a serial number. After that, is converted to second appeal.
Serial number of your case which was filed.
Amen.
So the RSA was not registered. That is why I was wondering what is that? Serial. At times they have different rules for this filing. That if removal of defects, then it will be numbered. That is why, no?
No, but your second appeal was not registered.
No, my lord. Only at that stage it was dismissed. At that stage, it was dismissed for filing of requisites.
So you could have, uh,
Peremptory order was filed. Remove the defects, not requisites.
My lord,
Removal of defects.
my lord.
so
not
your
requisites.
second appeal was
removal
defective. This is
defect.
what we are saying.
My lord,
Your second appeal was defective.
my
Where
lord,
is the question of restoration of a defective second appeal?
my lord.
My lord, what?
That serial number is to be restored. After that, it will be second appeal.
Today's
No, that procedure is no longer there. Second appeal directly registered nowadays.
There is no RS.
RSA, is it RSA, still RSA? But why have you not removed the defects for 21 years?
No, not 21 hours. I have filed petition for restoration. After restoration, I will remove the effect because it was dismissed. That is why it could not be removed.
When was that dismissed?
Oh, restoration is pending in 2003.
Oh, that's very good.
Dismissed in 2003.
So why this matter remained pending for 21 years?
My lord, I have filed for restoration, but it has not been listed.
And then meanwhile, the petitioner number 1 has died also.
My lord, he has died and I have filed the subsequent
He
petition.
died before dismissal or after dismissal?
After dismissal. So for that, I have filed 2 missed cases, 31, 32.
There's also the serial number is given. Second appeal.
My lord,
You can file a fresh second appeal.
second will.
Yes.
There will be limitation.
Explain. Delay, you can explain.
There will be limitation, my lord.
You can explain that delay. That you file restoration application and thereafter that the restoration application remained pending for last 22 years, 21 years. And therefore, and the system has changed.
My lord,
Your second appeal was not competent because it was defective.
my lord, that may be observed. I will file the second appeal.
All right.
And the certified copy may kindly be returned.
This application has been filed for restoration of serial number 4359 of 2002, which stood dismissed for default as the petitioners failed to remove the defect within preemptory time. Stop. It is an admitted fact that the appeal against the judgment of the first appellate court
My lord,
that the appeal against the first appellate court filed by the petitioner was defective and therefore not competent. First off, the defects, the petitioner failed to remove within preemptory time. First off, when counsel appearing on behalf of the in the meanwhile, petitioner number 1 died. First off, when counsel appearing on behalf of the petitioner submits that he may be allowed to withdraw the present restoration application with a liberty to file fresh, what do you call it, RSA, regular second appeal or only second appeal?
Regular second.
A regular second appeal against the order of the first appellate court. First off, a judgment of the first appellate court. This application is dismissed as withdrawn with the liberty as sought. First off, it will be open for the, you will file your limitation application.
My lord, the judgment which I have filed, certified copy may be returned.
Let the certified copy of the impugned judgment of the first appellate court be returned to learned counsel for the petitioner. First appellate court brought on record in serial number 43902 be returned to learned counsel for the petitioner so as to enable him to utilize the same filing the regular second appeal.
Certified copy.
Certified copy.
That means you have not filed the original, the trial court judgment, you have not filed.
That was
That was the
the
defect.
that was defect. That was the right.
He had filed.
No, that was not.
Then what does he want to return? Oh. Yes.
Well,
Item number 3.
Your Lordship, as per Lordship direction, the OP number 3 on the last occasion file an affidavit to which I have already filed a reply. Copy also today I served to my learned senior.
The reply, my learned friend has objected 2 points, my lord. First point is he has challenged the market value fixed by my officers, which I have indicated in my affidavit. Second is penalty, why I have charged penalty. Regarding penalty, your lordship may adjudicate, but regarding the market value,
Regarding?
the market price which our officer has quoted, he has disputed that, giving the benchmark valuation. So I require clarification from my officers why they have, whether their statement is correct or their statement is wrong. I will require further clarification.
This will not, matters shall not remain pending anymore. We will decide.
Right, man.
This is 2004 matter.
My Lord, in order dated 1/8/2024, your Lordship directed to file an affidavit on the basis of my submission that I am ready and willing to pay the license fees till today as well as market value of the land.
Yes.
And in the affidavit filed by the OP number 3, they have calculated that the area, the license fees is 12 lakhs somewhere, and GST I will also pay. I am liable to pay. But the penalty they have imposed 79 lakhs 3,000 somewhat, my lord.
Don't pay.
And a penalty, it is pending since 2004, my lord. They couldn't give me the possession. There was an unauthorized occupancy by
You may
some.
win.
Pardon, my lord?
You may win the case, argue on merits.
My lord. My lord.
You may win, you may lose, we don't know.
On the last occasion, my lord, I gave a suggestion that since the land is lying vacant and I am ready and willing to pay the license fees and the market value of the land, Your Lordship directed to file an affidavit.
Do it.
If my Lord Senior will agree, then without penalty, the license fees I will pay.
Why? He does not have the authority.
He cannot
Right.
agree, he is the counsel. How
My
do you
lord.
agree?
Lordship may see, if the land was allotted in the year 1998, due to some reason, due to the RDA couldn't give me the possession of the land, I couldn't start my
So
business.
penalty
I
has
couldn't,
been awarded under which provision?
pardon me.
Penalty has been imposed on which, imposed under which provision?
Provision, my lord.
Penalty actually, my lord, from all our allottees, those who have defaulted in making the monthly license fees, we charge 5% penalty for the defaulted amount. So that is,
Where is that?
right, that is on the basis of an agreement which he failed to execute from the very day of allotment.
All
He
right.
never come up to
What is the
execute the
total?
agreement.
What is the total amount?
Total amount,
Total amount which is payable by him, according to you.
yes, my lord, you see. And my calculation sheet is there, my lord.
Yes,
Page,
yes. Right.
Page,
93 lakhs, 19,834.
93 lakh.
19,834. That apart the market price of the land. This is the defaulted amount and plus market price of the land.
And
Plus the market price of the land.
what is that?
The land to be leased out to him.
yes, what is
Lease
the price?
pardon, my lord?
What is that amount?
That amount.
1 crore 60 lakhs some odd, Your Lordship, that they have stated.
And what is the penalty?
Penalty. Penalty is, my lord, for 5% for the defaulted amount, 79
No, my lord.
lakhs 3,444.
My lord, that 93 lakhs includes penalty.
Includes penalty.
My lord.
Include penalty, yes. Total amount 93 lakhs.
License fees is 12 lakhs 394 and GST 1,07,998 each,
So what is the total amount?
minus penalty, Your Lordship.
No, what is the total amount which they are demanding from you?
They are demanding, including license, including penalty, 93,19,834, 93 lakhs 19,834, and the market value just they have stated that it is 1 crore 60 lakhs 69,789.
1 crore 60 lakh.
69,789. 69,789.
One 160,69789.
Yes,
My
sir.
lord,
160,69789.
Lordship,
93 plus this.
my lord.
So the 12 lakhs is the GST or what?
No, 12 lakhs is the area,
Is the area.
and GST is, Your Lordship may see the affidavit.
The last
by-
page of the affidavit,
last
I have
page
given
of the
the calculation
Yes,
sheet.
last page of the affidavit I am seeing, paragraph 6.
Yes,
Oh, you made a table.
this is license
Table.
fees,
Okay.
license fee, CGST, OGST
Alright, alright.
and penalty.
Yes.
My lord, I have filed my objection stating, indicating that Your Lordship may see the benchmark value of the land per acre 20 crores and it comes to 60 lakhs. The value of the land, if it will be transferred in my name, and previously also nearby land they have transferred in name of others, Your Lordship, at the benchmark value. And they are claiming it's 1 crore 60 lakhs. It will be maximum 60 lakhs. And penalty part is concerned, my lord. Penalty in the entire year, I have tried my best to get the land. Because of their fault, they couldn't give the possession of the land. There is a case initiated, eviction proceeding was also initiated, though I don't have any number. but they have initiated an eviction proceeding.
So these facts are admitted. Are these facts admitted?
The eviction proceeding, my lord, I have.
No, that they
Any
could not give
fact,
possession.
Mr. Counsel,
I have written.
if there is any fact which is in dispute, we will not go into that.
My lord,
For that, you will have to.
my
file a
lord, in
suit.
my writ petition, I have stated that eviction,
Yes.
they
So,
couldn't give me the possession.
Writ proceedings are decided on the basis of affidavits.
My
No, we cannot take evidence.
My lord, in their counter affidavit, they have not stated that the land was unauthorizedly occupied. In their counter affidavit, they have not denied it.
They have
All
denied,
right.
paragraph 7.
Paragraph 7.
Yes. The allegation that OP3 was not able to deliver possession due to encroachment is not only incorrect but also contrary to averments made in paragraph 4 of the writ application.
Paragraph 4, they said, I have developed the land. If he is not in possession, how could you develop the land?
Entire land was not occupied, your lordship. Some portion of the land was occupied.
All right.
My lord, the land is still vacant, your lordship.
Maybe.
I am an unemployed
See,
person.
if
I am
land is
pursuing.
vacant, Mr. Counsel, if the land is vacant and the matter has remained pending here for 20 years, then someone else will do it.
Well, I am ready to give
No,
the
you are
license
not
fees.
ready.
I am ready to give the license fees.
No, whole amount if you pay, it's all right, otherwise we will decide what amount is required to be paid by you.
My lord, penalty part is concerned, my lord, it is
Maybe.
very huge and my lord, the market price also they are claiming that without any basis. I have filed the document that the market price of the land, the benchmark value of the land is.
Then let the land be auction sold.
The advertising has been stayed by your
governance
lordships.
will entire
Advertising has
effort,
been
my.
stayed.
Your effort, you are successful because you got an order of, got an interim order and the matter is pending for 20 years. So that land was in your possession throughout.
That is why, my lord, that is why I am ready to
That
pay
is why-
the
that is
license
why-
fees.
That is why we will decide. We will not keep such matters pending. 20 years, we will decide if any disputed, if we are not in a position to decide because of disputed questions of fact, we will dismiss your writ application on that ground.
You filed a civil suit.
Yes,
Civil
my
suit
lord.
was withdrawn, my lord.
Unconditional withdrawal, no condition,
Okay.
then writ
That-
application has been filed.
That was also.
Only because after the injunction order was modified to his detriment, he withdrew the suit.
Ruleless in such matters. This 2004 matter,
Blocking the
interim
plan.
order.
Lord, I am trying.
You
I
can.
am trying here from 2004.
You
your
will
lordship.
permit you to participate in the auction sale if the value is in the auction sale comes out to be less than what they are saying. It's all right. Otherwise, let some person who can pay this more than the amount which is being demanded by you. Let it take. You have not been able to start it for last 20 years.
I am not because of pendency of this.
Yes,
because
yes.
They have cancelled.
Because of pendency of what?
They have cancelled.
Because of pendency of what?
No, my lord. Because they have cancelled my allotment order. I have come here before lordship.
Therefore, because
So I
of
couldn't start it because they have cancelled it.
they cancelled it and this matter remained pending for 20 years. So they had not filed the writ petition. Writ petition was filed by you. And because of the writ petition, the development remained pending. So
I made an advertisement for auction that has been stayed by your lordships. Therefore, no auction could be done.
total amount, if you pay, it's all right. Otherwise, we will decide. Total amount which they are demanding.
Market value is.
All right.
Lordship, I will take instruction. I will take instruction. 1 week after your lordship call.
List this matter on Thursday within first 5 cases for the petitioner to seek instructions as to whether the petitioner is ready to pay the entire amount as com- as disclosed in the affidavit filed on 9/8/2024,
Yes, madam.
on 9/8/2024 by, on behalf of Rourkela Development Authority. So, if the petitioner expresses any inability to pay the amount, comma, the court shall decide, shall have no option but to decide the writ petition on merits based on the pleadings on record, considering the fact that the land which was made available to the petitioner, the commercial plot which was made available to the petitioner in 2002,
98, madam.
98. Your
in
Lordship.
1998,
11/5/98,
construction of a
12/5/98.
restaurant has remained vacant for last 36 years.
26.
26 years. Yes. As
Item number 4.
Lordship, call it next Thursday.
Thursday, yes.
Lordship, may call it on 23rd. Can it be?
Thursday.
Sorry.
Thursday you say you pay.
Right.
By Thursday you pay the amount?
Only, my lord, 1,300 square feet land. And they are claiming now more than, near about 3 crores.
Leave it.
More, near about 3 crores.
Leave it.
Then how a person will start his business on a piece of land of 1,400 square feet by paying 3 crores?
Leave that.
I will take instruction, but
Leave that.
It
See,
will
Mr. Counsel, we are,
absolutely,
there are two things.
absolutely,
We are not compelling you to pay. We are not asking you to
absolutely,
withdraw.
my lord, absolutely.
We are concerned about two facts. One, that the land has not been utilized for last 26 years. And two, this writ petition has remained pending for 20 years. And you have been enjoying an interim order of stay.
Absolutely, my
So
lord.
these are three things which are disturbing for us. We will decide.
My lord, the Rourkela Development Authority is only concerned on the consent fee, license fees,
See, Mr.
Suppose-
Mishra, one thing,
my lord.
even now if you buy it, it may be less, but because you have blocked the land for so long, that is
Absolutely, my
why the
lord.
price has become so
Absolutely, my
high.
lord. But
it-
suppose I would have started my
That is
business,
different, not starting,
lord.
that is different. No, you are saying that amount is exorbitant, that is
Absolutely.
because they've charged penalty because you have done nothing
penalty,
for so many
penalty
years.
for lordship will decide, I will pay the penalty, but not the market value of the land. I will be going on giving the license fees.
That is up to them, we cannot do that.
Then it will
Whatever
be
your
decided.
earlier
I will take-
agreement.
He may be correct in his submission
Yes, madam.
that
may not
now
purchase
since, now since you are asking him to pay the value of the land.
Yes, madam. No,
Then-
he suggested, he prepared to purchase it at the market price. He suggested, I am interested for license fees. I have given it on license. I am interested for collecting the
Alright,
license
so
fees.
you can take license fee,
Yes, madam.
then you can take the value of the land.
Value, he suggested that I will purchase it by market price.
So
I
you
will
are
be-
saying that,
Benchmark price and market price are different things,
so you
madam.
are saying it is not necessary to, for him to pay the price of the land.
Not necessarily, simple license
Absolutely.
agreement will be executed. You will
Absolutely.
be licensed,
I will pay.
pay the area license fee, take the license.
Absolutely, lordship may decide.
Yes, sir.
So if he pays the license fee and penalty,
Yes, madam.
you are ready to
Yes,
execute the lease agreement.
execute the license agreement.
Penalty
He
is little bit
suggested
high,
for
but,
license come sale, but I
Penalty-
suggested that it is a license agreement.
penalty is little bit high, but lordship will consider sympathetically because I have
no.
not started my business.
No, you have not
I have
started
spent my-
therefore.
I have-
See, we don't have sympathy because nothing could start.
Because I have to start my business. I have to construct over the land. I have to start my business.
So
Now I am at the age of 44, my lord. I have spent my more than 24 years I have spent
So
In the
you are not
meantime.
doing anything in the meanwhile.
Nothing, my
Then
lord.
this, you should not use this.
And I'm
You are, then you are worthless.
No, my lord, your lordship will consider the part of penalty. But that
Now we consider market price now.
the market price and penalty both will.
No, market price, they see.
Lord,
Market price, you are saying that this is unreasonable. They are saying that you may not be required to pay, you don't pay.
absolute liability
You
license.
pay the license fee, penalty, and they are.
Penalty is there, my lord.
No.
Your lordship consider it.
Item number 5.
So can we dispose it off?
It will be on Thursday
All
night.
right.
But the lordship, in that.
That amount of the license fee and the penalty because of and the amount of penalty. Penalty as indicated in the supplementary as indicated in the affidavit dated so and so to the tune of rupees 93 lakh 19,834. All right.
Lordship,
We
penalty
are
part
not
will lordship.
asking, you seek instruction.
Absolutely,
If your
lordship.
client doesn't agree, then you can tell him that we are going to decide it.
My client has enough confidence on the court that the court will
Very
consider
good, very good.
sympathetically.
Then there is no problem at all.
That faith should continue. That faith shall continue.
My lord.
Both of you.
It will be considered sympathetically with my client.
Sympathy is, there cannot be misplaced sympathy in law, you know. All right.
Call it on 19.
No.
Or 12, sorry. Sorry. 12. No, sorry.
Does not preclude you from approaching them and their sympathy.
My Lawrence, figure it next.
My lord, on last occasion. My lord, item number 5, my lord.
Item 5.
My lord has directed me to file an affidavit highlighting that there were two, whether, my lord, the petitioner, whether the respondent number 4, my lord, who has taken over the property by auction, whether they have paid the entire amount or not. My lord, they have already paid the entire amount. That is, there are two lots, my lord, lot number 1 and lot number 2. Lot number 1 included.
Yes.
My lord, the lot number 1 included land, building, plant and machineries, my lord. So, my lord, the contention of the petitioner was that when the transfer deed was executed, the land value was mentioned 6,30,000, my lord. Whereas the entire auction was, my lord, 12,60,000, my lord. Now, my lord directed me that why there is such a difference. So, to take instruction. My instruction is this, my lord. He has already paid 12,60,000. So, first, my lord, the honest money was paid 3 lakhs something, my lord. Thereafter, he has paid the entire amount. 9 lakhs and some amount, my lord, he has already paid. That affidavit I have also filed.
Well, that affidavit is my
At flag
lord, the
X.
annexures are not legible. It is only served on me yesterday. I will file a response to that, my lord.
Just a minute, you may file response, but we'll see whether that is required or not.
I have also filed the affidavit, my lord. I paid the entire cell consensus
Additional affidavit.
by OP number 4 also.
OP number
Flag
4 and
X.
OP number 2.
In OP
One
number
and
4, I have submitted the receipt, my lord. Entire cell consensus I have paid.
Flag X.
So there is no merit in that.
My lord, my submission is, my lord.
Yeah.
My lord, their counter affidavit that it was sold in auction, but fact remains it was sold on first time on negotiation. Here is also negotiation. My law says that if it is seized, they have to act as a prudent owner under section 29. Instead of putting it to public auction at the first instance, they have sold on negotiation. And property of lot number 1 is 507 decimal of land, more than half acre. It was cost would be more than, my lord, than 25 lakhs or more. And never a large number of area of building was standing there on. My lord, your lordship may kindly see the seizure list, the area of the building standing there on. For that, my lord, whether it can be sold on negotiation or the first instance or not, the counter affidavit is differing from each other.
You sold it on negotiation?
Yes, my
My
lord.
lord, it was sold
No,
after
no,
that.
my lord.
No, my lord.
Not
it
on
was
negotiation.
not on
Negotiation, word is something different, my lord.
Not on negotiation.
What is different in the word negotiation?
My lord, it was,
No, let us come to section 29 of the Act.
Section 29, my lord. 1. Where any industrial concern which is under a liability to the financial corporation under an agreement makes any default in repayment of any loan or advance or any installment thereof, or in meeting its obligation in relation to any guarantee given by the corporation.
What is that? OSFC? It's OSFC Act or what?
OSFC is State Financial Corporation.
No, it's Act. What is the Act?
This is
State-
a
same,
State Financial Corporation
Corporation
Act,
State
1951.
financial.
Why? So you are selling the decision of the financial corporation, the action taken under section 29.
My lord, yes. On the ground that on the first place, they have sold it on negotiation, but not in
Sale
public.
is subsequent. First
My
of,
lord, seizure is right. I am not challenging that.
then you don't have any right.
No, my lord, my law is well settled.
Law is
That-
what civil settle.
My lord, yes, I will cite the decision of the apex court, my lord.
In the action taken under section 29,
Seizure I am not challenging, but sale I am challenging.
sale you are challenging.
Yes.
On what ground?
My lord, that they cannot sell it on negotiation. And furthermore, without, for negotiation, they have to call me into the negotiation. They have not called me.
Let us see which provision.
My lord, I will cite certain decisions of the Apex Court,
Decision
my lord.
without law.
My lord,
Where is that? Where is that in the
my
law?
lord, interpreting section 29
Yes,
and more particularly subsection 4,
yes.
that the OSFC
Just a
must.
minute. Just a minute. Yes. So what do you get by challenging the sale?
My lord, because my lord, had it been put to public auction, it would have fetched more money, actual money. But instead of that, they have sold it on negotiation.
How much
And
more?
without my any intimation to me that it is going to be sold on negotiation. My lord, only I cite 2 or 3 decisions, my lord.
Forget decisions. Forget decisions. Yes, it was not auction sold.
It
No,
was auction sold.
My lord, see, kindly have a glance to the
Where is that notice?
page
Yes, my
21
lord.
of the counter filed by the OCFC, my lord. Page 21 of the counter filed by the OCFC.
Page 21.
Yes, my lord. That's the auction sale.
Auction
That's
sale.
not under challenge, my lord. That's the advertisement for auction sale. That's not challenged.
My lord, kindly see, my lord, the last but one paragraph, the loanees and guarantors, mortgagors.
Yes. Yes.
That's the sale notice not under challenge. And entire case of the petitioner that in the pleadings that the opportunity has not been given to the petitioner. And that the opportunity has been given, that's the last line, last paragraph of the page 21.
The loanees and guarantors.
Yes.
The loanee, guarantor, mortgagors of industrial assets, vehicles, as advertised are requested to appear in person or through their accredited authorized representative before the TDSC BLDC meeting or the date, time, and place mentioned in the said notice, where the proposal for getting release of the assets. They may arrange prospective buyers for their respective assets and ensure to appear or not giving any proposal to the satisfaction of the corporation before the DDSC will be construed that they have no further claim to the
Yes.
and this is deemed to as a sufficient notice to them. In entire ground of the writ petition, only opportunity has not been given.
Paragraph I of your counter.
My lord.
You say it was sold to so and so, so and so. They gave the offer in the meeting of the corporation held on 19/3/2008.
My lord, that is
Means
the,
auction failed.
no, my lord, auction was there. They were the eligible. They were called upon. And along with them, my lord, they had also been there.
What was the amount quoted by him?
Quoted by, my lord, for the lot number 1, it was 12,25,000. Thereafter, it was again quoted 12,60,000, my lord.
So increased it.
Increased on negotiation.
On negotiation.
Yes, ma'am. On
That is
negotiation,
wrong,
it
my
is
lord.
increased.
But cannot
He
be-
quoted 12,17,000, my lord, that has been increased to 12,25,000.
So therefore they
increased.
increased it.
Increased.
My lord, I am not on that, my lord, your lordship may kindly hear me for a moment, my lord. Your lordship may kindly see,
My lord, before that, can I submit one thing, my lord?
Yes.
Just one.
let
My
me
lord, he was given an offer that you please settle the entire thing by OTS, 13 lakh something, my lord.
That we
Then
said.
he also didn't come up. He didn't pay also the first 25% he also didn't pay. The OTS failed, my lord. Thereafter, we went for the auction, my lord.
That's all.
My lord.
Now, my submission is, my lord, your lordship may kindly see the advertisement for sale notice, page 53 of the brief, my lord.
Yes.
They issued for sale, my lord.
Yes.
On, that is, date is 19/3/2008.
Yes.
Then your lordship may kindly turn to page 29, annexure 9 series.
Yes.
I have taken the categorical plea that it was not put to auction at all, but it was sold on negotiation. Your lordship may kindly see annexure 9, page 29.
Yes.
In the negotiation sale of asset, my lord, paragraph 2nd, my lord, of lot number 2 land measuring such and such, the above was held with you on 19/3/2008, wherein you revised your offer to 1,65,000 only on outright purchase basis. So it was complete on negotiation, my lord.
Yes.
So my submission is, law is well settled that on the first instance, the the property of the assets or unit of the loanee cannot be sold on negotiation at all. If the auction fails, my lord, then it can be sold on negotiation. My lord, here also, with wherever Mahesh Chandra case, my lord, there are 3 options was given. First bid, then public auction, then, my lord, negotiation. Now, partly that has been overruled. Though it is overruled, later on it has also been considered by the apex court. Now, my lord, your lordship may kindly see, I have filed certain decision of the apex court.
Why are you jumping on the decisions of the apex court? First of all, tell us whether you responded to the sale notice or not.
My lord, my submission is, after the sale notice, since it failed, my lord, nobody appeared for auction. So, my lord, it was adjourned. Thereafter, no notice has been issued to me.
Did you appear?
My lord, I appeared on the date of auction, my lord. A date fixed as per the sale notice.
Where have you said?
That repetition is not stated, my lord.
But 19/3 was fixed for the sale. They have given the offer on 19/3 itself.
My lord, so it is for negotiation, not on public auction, my lord. Let them say and show the paper that how many persons appeared for the auction, my lord. Then I have no case.
They might have committed fraud. But what did you do? You did not appear.
Ma'am, immediately I have filed the writ petition, my lord. Immediately.
So why did you not appear? Why did you not respond to the sale notice?
My lord, my submission is, my instruction is that he appeared. My lord, some. And furthermore, my lord, law is well according to them. My lord, I have filed an interim application to recall your lordship's order, earlier order, with regard to lot number 2 mortgage, my lord. Mortgage property under no circumstances can be sold under section 29, my lord. That is the law, my lord. And in this honorable court, mortgage property was sold. That was set aside. Then the corporation went to Supreme Court, my lord. Apex court has levied cost while dismissing the civil appeal, my lord.
Yes.
So, my lord, your lordship may kindly see yesterday affidavit, page 2, my lord, filed by 1 and 2, paragraph 3. It is sold on negotiation, my lord, not on public auction. It is not their case that there was public auction was held, but since none appears, then negotiation was held. Nothing is there.
See, Mr. Counsel, you made your first submission that there was no sale notice. Sale notice is
No,
there.
I have said
Then
sale
you
notice.
said
My lord, I have
that
annexed that sale
you
notice.
responded to the said sale notice. There is no such statement. So you are making all irresponsible submissions. So whatever submission you may make, but that should have some foundation, some basis. Without that, you cannot make your submissions.
I am only
You
on
are-
the
you are-
point that it
you are-
cannot
you
be
are-
sold on negotiation.
That is your point. But why are you, we don't want to use that expression. You are misleading the court.
I'm sorry, my lord, my intention is
You
not
should
to
not,
mislead.
your intention may not be there. But why did you say that there is no sale notice?
No, my lord, I have said it is sale notice. I have not said that there is no sale
So why
notice.
did you say that you had responded to that?
My lord,
You said that you appeared.
my lord, I am not objecting that there is no sale notice. My only submission
Mr.
is,
Counsel, you said that you responded to that sale notice.
my lord, yes.
But there is no such statement in the writ petition which was
Nothing,
filed in
ma'am. Yes, my lord.
2008.
Obliged, my lord. Nothing is there.
Nothing is there, then what is you are making your submission on the basis of your personal knowledge?
No, my lord, I am only challenging annexure 9 in the writ petition, my lord. Sale by negotiation.
Yes.
And my further case is that it cannot, the mortgage property cannot be sold on under section 29 of the Act. That is law is well settled in that. That can only be under section 31.
Yes.
My lord, in that respect, I want to cite two decisions of the apex court, my lord.
Yes.
I have already,
Please take your seats.
Yes.
my lord, I have already filed the decisions earlier, my lord.
Yes.
It is before your lordship, my lord. 2008, 5 SCC. volume 5 SCC 176. Your lordship may kindly turn to paragraph 20, 21, 24, 37 and 41.
1993 volume 2.
2008 volume 5 SCC. I am on the ground that on my submission is based on that mortgage property cannot be sold under section 29. That is my case. In so many words, they have said that properties are mortgaged, but those are sold. In paragraph, my lord, your lordship may kindly see paragraph 20, my lord, first. Section 20.
Just a minute, let us see where is your judgment.
My lord.
Let us see where is your judgment. We are trying to get it.
First.
No, it's not first.
Your lord, if your lordship permit, I have submitted all these documents, citations.
It is there.
We are
Mr.
looking for it because
My lord,
the
yes.
page is not available.
Which paragraph? 2004 volume 7 SCC 151.
2008, my lord, 176. 2008 volume 5 SCC 176.
2008 volume 5 SCC
176.
paragraph.
Your lordship can turn to paragraph 24, my lord, directly.
It is not there.
My lord, to taken on some of that, I will again.
No, sorry.
My lord, I am prepared, my lord. But
Yes, we are also prepared.
What is that decision?
my lord, first decision is
Mahesh Chandra.
2008 volume 5 SCC 176. The other is, my lord, AR 2015 Supreme Court 542. And another is AR 2007 Supreme Court,
Just a minute. Here.
AR 2007 Supreme Court 3131, para 22 and 23. Then, my lord, AR 2015 Supreme Court
So many.
542, paragraph 7. Then, my lord, 2008, volume 5, Supreme Court 176, paragraph 24, my lord.
Yes.
2008, volume 5 SCC, page.
176.
Yes.
Shall I place, my lord?
This is your proposition. We will see what is there in the
My lord,
We will find out what is there in the judgment.
my lord,
Anything else?
my lord.
Anything, any other submission?
No, my lord, no.
My lord. I submit one decision of Honorable Supreme Court.
Yes. Yes.
My lord, para 19, my lord.
Which decision?
My lord, Karnataka State Financial Investment versus Development Corporation. This is my lord, 2005 4 SEC 456, my lord. Para 19. This is the principles that they have laid down with regard to section 29. Only we are relying upon.
Yes.
This is only para 19 I am relying upon.
No, but what about his other submission? That the mortgage property could not be auction sale.
But these are all industrial assets,
Auction
my
sold.
lord.
Huh?
These are all industrial assets. And he was directed by this honorable court to give documents whether whatever property he is claiming to be mortgaged or not, which he could not place, and my lord had dismissed that regarding lot number 2, my lord. In
No,
previous,
that was on a different point.
yes, my lord.
Not on the point that mortgage property cannot be sold. That
The
was not on
mortgage
that
property,
point.
my lord, here it is all industrial assets which were seized and it was put to auction, my lord. There were 2 lots, lot number 1 and lot number 2. So lot number 1 and 2 were put into auction, my lord, where sale notice were published, and my lord, it was the auction was conducted. They came, BLDC
So the
meeting
property,
was.
the land belonged to whom?
The land belonged to, my lord, to the
Petitioner.
petitioner, my lord.
Yes.
It was given in it was given to us on mortgage, my lord.
Mortgage.
My lord. So it was 2 industrial. It became industrial assets, my lord. Plot number 1 and lot number 2.
This thing that did those 2 parties succeed in the auction sale, have you stated anywhere?
Auction sale.
Or you have stated that they gave the offer and they have been sold?
They have it in my counter, my lord. I have given.
Where?
My lord.
Where? Because I found the word sale written.
My lord.
I may have missed, but
My
please point out.
sorry. I'll just keep.
Because the section says sale.
My lord. My lord, It is at page 5, my lord.
The counter affidavit. dated-
Yes, H1, my lord. H, starting with H.
Which counter affidavit?
My lord, filed by me.
Original one.
Yes, my lord.
1 and 2.
Yes, my lord.
Page
H, page 5, para H, my lord. Since the petitioner did not pay the dues of the corporation, the seized assets were put to auction sale after advertisement in the newspaper Samaj dated 10/3/2008. Petitioner was also informed about the date of sale and also by a public notice as mentioned in the sale notice published in the daily newspaper the Samaj 10/3/2008. Thereafter, the industrial assets containing industrial land measuring 507 decimal building, plant and machinery of the unit was sold by annexure 14 to 1 Srimati Kalpana Mahapatra for a sale consideration amount of rupees 12,25,000 and another patch of land measuring 0.790 was sold to Sri Aravinda Mahustra Trust for sale consideration of 1,65,000.
Petitioner was informed how?
Petitioner was informed, my lord, in that BLTC in the sale notice, my lord.
In the sale notice, the petitioner was informed.
Yes, my lord. I'm showing it again.
So no separate letter or anything.
No, my lord. No, my lord. My lord, at page 21.
Saying that you had participated in the sale. In your writ petition, you said you were not aware of the sale.
No, my lord.
No. So it is not correct that you have
My
participated.
lord, yes.
Your
My lord,
stand was
it
that
is
you
a
were not
transfer
aware.
deed, so I have nothing to say, my lord. But fact remains, my lord, in pursuance to your lordship's order dated 27/7/2023, I filed I-8 flag P, my lord. There I have in detail stated about lot number 2, which is a pond. They have admitted it. And it is more than 100 meters, 200, 150 meters from the unit. Your lordship may kindly see for a moment. And in the argument, it is order sheet that it is mortgaged. Your lordship may kindly see order dated, my lord, 26/10/2021. The OSFC said the mortgage properties has been sold. Their submission, and that is the order, my lord.
Fine.
Yes.
My lord, order dated 26/10/2021, my lord. Second paragraph, my lord.
Yes.
Shall I place, my lord? Second paragraph, order dated 26/10/2021.
What is it?
There the OSF says categorically submitted that mortgage property has been sold. That is the order of this honorable court, my lord. And accordingly, I have filed an IA stating that the lot number 2 is a pond.
Which order you are referring? Which order you are referring to?
Our order of this.
Yes,
court.
yes. 26/10/2021.
We could not give the.
Paragraph 2, my lord, of that order. Towards last.
26/10/2021.
Yes, my lord. Yes. Second paragraph towards last sentence, my lord. Whereas counsel for the financial corporation submits that the due process of law was followed before disposing the mortgage property of the petitioner for non-clearance of the outstanding dues.
Just a minute. In order dated 26/10/2021.
Yes, my lord. Yes.
Which paragraph?
Second paragraph, my lord. Towards last.
2016, 2021 in the present case.
Yes, sir.
My lord.
Third.
Land council for the opposite part 3 and 4 submits that after purchase of the property in public auction in the year 2008, it was sold to many other parties, whereas council for the financial corporation submits that the dues, that the due process of law was followed before disposing of the mortgage property of the petitioner for non-clearance of the outstanding dues. Only I want to place this, that the mortgage properties.
All right. That's all.
My lord, if your lordship will permit, I will give the copies of the citations, my lord.
Give it because they are not there on record.
My lord, I am giving, my
You
lord.
had given another set which is there, not this.
And have
The
you
other
taken this,
decisions we had filed regarding, my lord,
Please.
auction sale negotiation, those things.
this ground you have taken in your writ petition?
No.
What, my lord? On my rejoinder, I have categorically stated, because earlier I stated that the sale is not valid.
All right.
But-
So you have been changing your,
But in rejoinder repetitive,
We will see, we will
detail I have stated, my lord.
you are relying on 2008 volume 5 SCC 176. The property was mortgaged by you.
My lord,
The property was mortgaged by you
by my mother, my lord.
or by your mother.
Yes.
So she was the guarantor.
Yes. And now during pendency of the divorce, he is dead. The first decision, paragraph 21 and 24, my lord.
Yes, yes, yes.
One of the decision is from the son of the Bona.
And was the decision of Justice Chauhan regarding notice to the adequate notice regarding auction, I think. That was
Yes.
not under the OSFC, that was bank, I think,
Bank and
Bank.
securitization.
right? Securities.
Securitization.
On securitization.
Yes. Yes.
My lord, kindly see he has given two mortgages about the land. The land was only mortgaged, not the plant and machinery.
All right. So to the extent he refers to the land, he is right.
My lord, land can be, my lord, land when the first charge was of the OSFC, my lord. My lord, if my lord will see
No, that is not the question. The
My
question
lord.
is that had the land been belonging to him,
My
the
lord.
matter would have been different.
Matter
But here-
it belongs to him, my lord, because my lord, see the transport deed, my lord, first land that, my lord, the lot number 1, transport deed, my lord, just I'll read it out. This is
Transport deed-
his rejoinder, my lord, rejoinder filed by the petitioner. In the transport deed, my lord,
Flag X.
yes. My lord, in
Which additional
transport deed,
affidavit? There are so many affidavits.
my lord, page 3, page 89, my lord, page 3 of the transport deed. My lord, whereas the last ice factory,
Which document you are reading?
my lord, from the rejoinder filed by the petitioner, my lord, where he has given those transport deed, where he showed that valuation is only, land valuation was only 6
Is it
lakhs.
there?
What are you referring to?
That transport deed, my lord, annexure 2, the annexure,
You filed it with what?
I have not filed, my lord, petitioner has filed,
Along with his?
along with the rejoinder, my lord. My lord, affidavit date,
Additional agenda is page 86.
86, that is
Page
the
86 of your lordship's brief.
No, give the date of that document. Of your rejoinder. There are so many documents we are finding it difficult to find. One rejoinder is
that
dated
is, my lord,
15/7.
given on 26/8/2022 when I have received.
Okay, 26/8/2022. Additional affidavit.
26/8. 26/8 must be 22.
So does it have annexures?
Yes, my lord, 2 annexures, 13 and 14.
There's no annexure, so it is not this one. Annexure 13 and 14.
Yes, my lord, I'm relying upon 14.
That's from 102, page 102 of your lordship's brief. 2 registered cell lists, annexures are.
Yes, got it. Rejoinder affidavit by petitioner. Yes, 246 of our running page.
Where is the document?
Document is annexed to that. Close. You are referring to the deeds.
Yes, my lord.
So
What is the
Which deed? First one.
first one, second one, my lord?
Yes.
That is
Wait.
the
First
lot
one.
number 1.
First one is in English, second one.
Lot number 1, my lord,
Wait.
may come to running page 3.
Internal page 3.
Yes, my lord, internal page. Sorry.
Transfer deed between OSFC and Kalpana Mahapatra.
Yes,
that
yes,
one.
my lord.
Yes.
Yes, my lord. What is the, my lord, there it is written,
Running page, just 1 minute. Were written on top.
my lord, after second, and whereas the La Glass Ice Factory Cold Storage Proprietor Sri Dilip Kumar Rai, borrower, had availed loan from the corporation, and as security of loan advanced to the borrower, he had provided mortgage of industrial land. So he had mortgaged that land. So now he is saying that
No. He has mortgage. If the land is not in his name, how can he mortgage?
My lord,
The guarantor has to give.
My lord, it is their document. They have prepared this.
this is the document, my lord. Now, my lord, this is, he
He
has,
may have provided. Guarantor also he has provided.
my lord, then
Who
let
does the
him,
land
that is the
belong to?
reason, my lord, he was asked to provide that, that was the order of the court, my lord, where he was asked that, that he should provide the details that how it was mortgaged.
Not how it was.
Yes, my lord, kindly see.
How it was mortgaged means it was mortgaged to
Mortgaged
you.
by him or by his mother. Let him give the documents, my lord.
My
That
lord, it
was,
is a simple mortgage. Your lordship, no, my lord, by depositing. the
my lord, he
deed,
never
simple mortgage
deposited
is
the money.
created under section
Now, my lord,
58
all
Not
the,
money,
Transfer of
the
Property
deeds.
Act.
I accept,
in
my
that
lord.
case, no
No, my
document
lord,
is
for
necessary.
last so many
Provided to
years,
the
my lord, from
lorry.
2000, my lord, he has
Lordship,
not
kindly see
deposited
section
the
58
outstanding
of the
amount.
Transfer of Property
Now
Act.
he's saying that these are not mortgaged by me, but by my
No,
mother, my lord.
there is nothing wrong. He has to provide the guarantor.
My
Guarantor
lord,
is
whatever. So
provided.
it is the first charge that we have taken over and we have auctioned it, my lord.
No, that is not the question, Mr.
My lord,
Counsel. The
sorry, my
question is that the land was not mortgaged by him because the land did not belong to him. His mother was the guarantor
My,
and the land was mortgaged by his mother.
my,
In that background, his stand is that the land could not have been sold
my lord.
by you in
My
auction
lord,
sale
my-
in exercise of power under
Under section
29.
29.
This
My
is
lord.
a submission.
My lord, can I answer it, my lord?
Yes.
My lord, he has mortgaged that property on behalf of his mother, if at all, my lord. Now, my lord, what is coming out, my lord, the land which was mortgaged to us was done by him. Now he says that my mother has given the guarantee, it was a property belonging to his mother, my lord, but it was mortgaged by him, my lord. So we have auctioned it.
See, but you should have verified that he cannot mortgage a property which does not belong to.
Because
that does not
that's the
belong to
reason,
him.
my lord, we
Because
had
when
the
he gives
first
the
charge over
property,
it.
you have to look at the.
My lord, due diligence has to take
No,
place.
due
my lord.
diligence, even some document showing that it has been recorded in his name or something, or he has
My lord, old
something.
documents, my lord, now, if you go back to that, my lord, it will be very difficult for us, my lord, because now the property has been sold, they have come into possession, now they have again sold it to
See,
somebody.
the property was sold by you, but whether you had any right to sell the property is the question.
Because, my lord, the first charge was belonging to OSFC, my lord. So when it was first charge, my lord, there was no other charge on the property. So that's the, my lord, we had put it on auction, my lord. He never complained about the auction, that at that time he never made any submission that it is a mortgage property or anything. He never participated or he never came to the auction, my lord. All these things he never disputed at the time of auction.
He did not come because he knew that is not going to
Because-
adversely affect him.
Because, my lord, it
He
was
was
the land
smart
was
enough.
mentioned over here.
He has filed
knew.
his writ petition immediately.
Yes, my lord. Thereafter, my lord, he has filed, but he has never mentioned that this mortgage property belongs to my mother. All these pleadings are not there, my lord.
There is no question of pleading, Mr. Counsel.
My
You're-
the law, this property was in first charge of the OSFC, my lord. So we have mortgaged it, we have auctioned it. And in the sale notice, my lord,
Yeah, that's all.
my only thing that I would say, so my lord, from this page 21, that is of my counter, the sale notice, there, my lord, the loanee and guarantor and mortgager of the industrial assets were informed, my lord.
Yes.
I'm the bona fide purchaser, my lord. I'm the bona fide purchaser.
You are the bona fide purchaser, but whether.
No, my lordship, what, before going for participating in the auction, I've also inquired about the case, and he has also filed one document at Annex 3, my lord. That was in the year of 2002. 2002, it was taken over possession, and
Taking over possession is one thing, but transferring is another.
no, my lordship, before going to take participate in the proceeding, I've inquired into, and in 2002 it was seized and taken over possession by the OSFC. And then and there, he did not come forward to settle the issue and did not file anything. And second, and
That
once,
is not challenging.
no, but I'm
Taking
saying
over
not.
of the property is fine.
And Annexure 3, my lord. Annexure 3, my lord, first sale notice. First sale notice
Mr.
in the year of.
Counsel, he has conceded to all the points and he is now pressing only one point.
Yes, ma'am.
That the mortgage property could not have been auction sold in exercise of power under section 29. That's all.
This is about this first sale on under Annexure 3 and page 21. He was also requested by the corporation to get release the unit. You are no longer, if you are no longer interested to get the unit released in favor of the and buyer arranged and be arranged to you and match the better first reference, and OSFC will be free to take such action against the deemed necessary to dispose of the unit through the public auction negotiation at your risk responsibility. This notice and concerned paper publication shall be deemed as sufficient notice to you in this regard. And this was the auction date was fixed to 30/11/2002. That's failed, my lord.
Which you have relied on,
My lord.
whether in those cases the guarantors had approached or the loanee.
My lord, in the our High Court case, my lord, my submission it is probably the loanee.
No, probably. Please don't do this.
The copy is not with me.
You are relying on decisions of Supreme Court.
My
You will
lord.
have to tell us that whether in those cases the guarantors had approached or the loanee. Whether this plea you can take or not.
My lord.
And
But
whether
my
when
lord,
you're
My lord, in one case, my submission is, it was a company was the loanee. Company was the loanee in one case, my lord. One of the, my lord, director had mortgaged the property. And it is held that cannot be sold under section 29.
you are right. But whether in
My lord, that I have not checked, my lord. Sorry,
that
my
you have
lord.
not checked, then you should not have relied on.
But law is that, my lord.
The wife and children of the mortgagor had approached. Child of the mortgagor.
Yes, no, why don't we can know that? Have to say. Relying on decisions without even verifying, and then your mother could have approached and in view of the notice.
My mother has expired, my lord.
When?
During pending just after filing of the present
When?
report. 2008.
She could have responded to the so-called sale notice. Because that was for the
Now,
guarantors also.
After death of my mother, I am the only legal heir, my lord.
So that is why everything is valid. Therefore, you cannot change. We will see what can be done.
Lord, my last submission is lordship permit, my lord. It is our ancestral property inherited by mother. Now I am prepared to pay the entire amount within 15 days, my lord.
That has been also sold to
So you
number
can
of
do
persons, and
After
they have
sale
also
also,
constructed the
Apex
houses
Code,
there.
if there is some illegality or irregularity, Apex Code has directed also this honorable court to
Just
pay
one
the
moment.
amount, some cases with interest.
I was thinking that is the problem. OSFC property, industrial property. How can you build your houses in that industrial region?
And my lord, just after
No,
sale,
not
they have
the
demolished
industrial
the
area, but that is the private area.
Private area of the petition.
And he has also sold some properties to us, my lord, the petitioner.
It is in near about Satpada, my lord.
The Satpada,
No, not Satpada.
that has been resold.
No, that's not the Satpada.
So now the question of
That
recovery.
Kalupada Ghat, that a Tangi
But that is
area.
lispendence, my lord. Lispendence of the herit. That is lispendence.
you relied on 3 Supreme Court's decision without telling us as to who had raised the objection.
Item number 6.
Mr. Mahapatra is running with temperature.
Sorry.
Mal. He's not come to court. He is running with
Sorry,
temperature.
Mr.
Attacking the counsel for the petitioner.
We can, when do you want?
Next week, any day.
We can grant you 4 weeks, but we will vacate the interim order if there is.
I am for the petitioner, Your Lordship. Your Lordship heard the matter and Your Lordship wanted, I think, to possibly decide today. So on that point, whether 68 or 25 will be applicable.
Yes.
I think he is praying for time for the opposite party. I am for the petitioner, I am there, my Lord, for Your Lordship. So Your Lordship only.
He's for the opposite party because you are there for the petitioner. So he's asking time for the opposite party only.
Yes.
My Lord.
The matter has been heard at length.
Yes, my lord.
Wrong. Next position.
Item number 7.
My learned Mr. S.P. Mishra was arguing this matter on the last occasion.
Who?
My learned Mr. S.P. Mishra.
Oh, what argue?
My lordship, I'm praying for one Passover. He's on his lecture, lordship.
We are here, great friend.
For a coordinate bench, your lordship, he was present over here. Praying for one Passover, your lordship.
Lordship can take it up to, let my senior come, I am there.
Sorry,
Lordship can take it up at 2 o'clock.
2 other cases are there, but can take up thereafter.
No.
What was this matter that
OGLS matter where they challenged the order passed under section 3B, resumption of the land on the ground that the settlement was made on a fraudulent manner, because the person whosoever land was settled is not eligible to get it because he is not a landless person.
yes, yes.
So my learned senior lordship, remember that day directed him to give the compilation of the entire OGLS law from the date of inception till date. So also the lease principles in the state, because they said that it's not covered under OGLS, it's covered under the lease principles. So my learned senior said that he has got all the documents, he has not, but he has not compiled it in a spiral binding. So he wanted some time to make it a.
Are the documents ready or Mr. Mishra has come?
Documents, my lord, senior has got it. Documents. My lord is asking about the documents.
Yes, Lord. The other day. I've got all the compilations. But only thing is, I was telling my friend, I'll make a booklet so that it will be convenient for us to go through it. Next Thursday, if you keep it, I'll in the meantime prepare it.
I will get
all
it
the
also.
action. Well, this is Rathod the other day indicated. I've collected. Here's the previous act and rules.
Of your
In a lighter vein, when I joined
No,
practice.
you can see this also, I have got it.
If you want an adjournment.
No,
you show a
whatever,
list of
this
books
matter
to
is
support.
pending since 2000.
I want to argue that matter, in fact, these are relevant for your lordship to see. So Thursday,
As
If
requested
you're
on
seeing
behalf
this.
of the petitioner, this is matter
Yes,
on.
yes, I am scared. It served its purpose.
your lordship send more thicker briefs. No, this is not that thick.
No, when you show us thicker laws, in fact, briefs we can, but when we have to read laws, then we require to read, like, requires much more concentration than
Right.
reading a brief. Yes.
Item number 9.
I'm sorry, sir, but interim order is there
Interim order, sir.
till next Thursday.
Item 9. They will be taken up next Thursday. And senior Mr. India was supposed to handle this matter because of some medical emergencies.
Yes. Next week. as requested.
Item
Item 9.
9.
Item number 10.
But Mr. Das, item number 9, is Mr. Patnaik appearing? Prasanna Kumar Patnaik.
In fact, last occasion lordships intimated Mr. Khuntia to call, so intimate him so that it can be done. I will obtain instruction from
Because I
Mr.
remember 1 month back, he was unwell, he was asking for time in some case.
That's why lordship asked Mr. Khuntia to intimate him over
All right,
telephone. So
all right.
I will have him to
All
call
right,
from
sir.
Mr.
So please inform him about the next
Khuntia,
date
yes.
also.
Item number 10, my lords. It's a private tenant at Parampur matters. We want that land should be protected, but the owner is going to sell out.
Private land with the pond.
Pond. It's going to be sell out. My lords, I have already last date I've given that judgment of our Honorable High Court, where that Honorable High Court said that private pond should be protected, nature and character should not be changed. My humble contention, it should be maintained. The owner should not be allowed to convert it or to sell it apart for the residential or any other purposes. Now, my learned friend has come up with an affidavit. He is appearing for the opposite party, and contesting opposite party means the private of the owner.
The tank has been recorded, your lord.
Please.
Yes, Mr. Mahapatra, continue.
But now he wanted to file an affidavit. He gives me a affidavit just now.
What is there in the affidavit?
In the affidavit, I have given some RORs that some of the persons, including the petitioners, they have purchased a portion from that pond. They have converted it to Gharbari 2. And I also want to demonstrate that pond has lost its characteristics, your lordship. That is the main purpose of the affidavit.
Mr. Biswal, it will lose its characteristics if you fill it.
I have not filled it, your lordship. The status quo was 11, your lordship. With the effects of time, the pond has lost its characteristics, your
It
lordship.
will become, unless you do not maintain it, it will become. But what is it recorded as?
Settlement record,
No, sure.
during settlement
I have to
operation.
concede to that effect, your
A
lordship.
portion of the plot area, 1 acre some odd, that is retained. Other portions of the area, means 2 acre some odd area was there. My father purchased a plot minus long since. It is 18 decimal out of 1000 decimals. 18 decimal only. Means 800 to 900 square feet. And that too long since. Now we are on pond. That pond is a separate plot. And that pond to be maintained as it is. The settlement record shows that the municipality is going to top the garbages. Recently, the other persons, they are going to top the garbages. In the process, gradually manage squaring of the pond and changing the nature and character of the pond.
PIL? So, but you are raising your own problems.
See, near the property, near that pond, you have property.
No, near the pond, I have a property in the lane, not in so far that
He
particular
has
pond
a
area.
property
In
in
the
the
lane,
embankment, your lordship.
not embankment.
Which he is facing.
Not nearby.
It's on the embankment.
Well,
erosion.
just-
Kindly
just-
verify those
just a
photographs, which I am producing today. Your
Trying to
Lordship.
visualize one thing. Pond is at over 1.700 some odd decimal. Around that pond, there are a lot of areas. To around one acre. Out of that, my father, since 40 years or 50 years before, purchased 18 decimal of land. It has nothing to do with the pond. Pond is when it's recorded so far the settlement record is concerned. It is recorded as a pond. It is a private pond, I admit. Only thing is that in view of the decision of our Honorable High Court, pond, even if it is a private one, maybe public or private, it should be retained and for the purpose of environmental balance.
Private pond, how is the municipality dumping?
Earlier, long since. That is what the settlement authority recorded.
That is not the pleading.
That is a wrong
That
statement, my
is
lord.
not the pleading.
No,
In
that is a wrong
counter-
statement, my lord. I am appearing for the municipal corporation. So in my counter, I have
Please,
filed
everyone
it.
sit.
My lord.
Please, all of you sit, all the three. All the three, please take yours. Yes, petitioner.
Yes. The, let's kindly have a glance. To my lords, Annex 2. Page 12. This is the last settlement. That is in vernacular Odia, my lords. That is in the name of opposite party number, my lords, the private opposite party number. My lords,
Come to your prayer.
my prayer. My lords, to maintain as to why there shall not be a direction to maintain the pond situated in ward number 5 of Barapur town, Mauja,
So
Badbajar.
this direction is required to be issued to whom?
Matters to the municipal corporation or matters to the, it is usually issued to the municipal corporation.
So the private pond is to be maintained by the municipal
No,
corporation.
municipal corporation will in turn will give a direction to the private owner. You maintain it as per the municipal corporation act.
How will he maintain?
Well, he has to maintain my lords. Then the thing is that only thing is that to protect the garbage, to clear the garbage.
So for protecting the environment, he has to ensure that that pond is properly maintained.
Yes.
No garbage is put. That is his
must.
own private land, but because of the pond, it is his duty.
Yes. That is what my lords.
I may be mistaken, but I think there is our decision
Yes,
that
I've given that last
the
time, my lord.
municipality is also under duty
Under duty
to
to maintain
maintain
it.
private ponds
Yes.
because it is ultimately
Yes.
for public good.
Public good.
So if he cannot maintain, the municipality can also maintain.
They can request the municipality can maintain. That is what I've given that judgment.
That
my
is
lord.
there.
That I've given that judgment reported in the ILR.
All right, when did
Incidentally-
you file this writ petition?
My lords,
When did you file the writ petition?
that is in 2011.
2011. So in 2011, the land was pond.
Yes.
How?
Well, that was point, that is a settlement authority recorded it is.
Settlement authority is had recorded. Settlement authority, whether it was a pond as on 2011 or not, is a question of fact.
Yes,
How do you say? Where have you said that in 2011 it was?
that is the point, and that to my lords, may I submit one thing? In this case, the municipal corporation also filed an affidavit.
What?
Admitting that it is a pond, but it is not in a goods condition.
It is a pond.
Yes.
All right. Where is that?
Well, that municipal corporation.
This
filed-
who has given these?
I have given my lords.
That
You
is
are?
it. That is it.
You are the private opposite party.
Yes, your lords.
I have also given some photograph. I think it is there or not. One few photographs. Few photographs. This is how much things are being maintained. Well, garbages are being dumped. There also I find some photograph.
Who is for the corporation?
Corporation might not be friendly.
Please sit.
I am there, my lord.
Please sit.
Corporation filed the counter that is on 26/10/2020, 26/10/2022, my lords.
And the opposite party has filed. It seems you have encroached upon the pond using it as a sewer tank.
Yes.
You have also encroached upon portion of the tank of the pond and using it as a sewerage tank.
Sewerage tank, my lords.
You.
Myself.
Yes.
Yes. I have also alleged that.
The
Not
municipal-
alleged.
You
That
are
is
using-
alleged against you.
Means,
That is alleged against you.
if that is so, my lord, this can be demolished.
No, your petition should be dismissed.
Well, my writ
Because
petition,
you are
I
interested.
in regender, I categorically denied that this fact is not correct.
No, we
All
are,
right.
we are entertaining a writ petition. If the writ petitioner has some interest, direct, he is using
I
the.
don't have my lord's direct
Yes.
interest. I don't have any direct interest.
We
My
may
humble
entertain,
contention
we may
is,
entertain the
well,
writ
that
petition, but
it
in
is-
your
it is-
absence.
but it is PIL. My lords,
Exactly,
I know-
exactly. Yes.
It is PIL.
That is what we are
My
saying.
lords, I am to bring to the notice of my lords.
No,
only
we may entertain the PIL in your absence. The petitioner will not allow the petitioner to continue this writ petition, PIL.
Because my lords,
You are interested party.
I am not a my lord interested party there, my lords. I don't have any interest. I don't have any interest. Only thing is that sometime my
that
lord
statement?
PIL is filed and
That is,
things are my lord set up in that way.
private opposite party number 5.
Once that judgment is there, my lord, I have
Yes,
given
yes,
that judgment,
yes,
my
we'll go
lord.
into that. We'll go into that.
Mr. Counsel, the judgment is there, but we have to test your bona fide
Well,
also.
All right, man. My lords, the happening is, that suppose my lords, I am coming forward and
The
saying
counter
that,
affidavit of OP number 5.
that I filed a rejoinder to that.
Yes.
I said that is not correct, and if it is so, I categorically denied.
Used for the public purpose.
I categorically denied. My intention only, my lords,
Your
may I submit-
intention we can understand.
My prayer is, the pond should be maintained as it is. And if somebody wanted to convert it, this should be converted in accordance with law.
That is there.
That is there. And that, how this should be converted, my lords, pond would be
there
converted,
in that
that
decision.
Honorable High Court has laid down that procedure so far Cuttack is concerned. Now, my lords, may I submit, my lords, I am not consuming much time. My learned friend is giving an additional affidavit today. I don't know what is there in that affidavit. So maybe taken up on Monday or Tuesday, my lord, so
One
then
moment.
Monday, there's a holiday.
Yes.
Tuesday. That I can go through, my lords, I can.
Now come to paragraph 10 of the judgment of this court.
Paragraph 10 of the. Paragraph 10.
This was also PIL.
Yes. Incidentally, my lords, I was counsel appeal proceeding in that case.
Cuttack, CDL.
Ashirwad Patnaik.
Sirpal Patnaik. No, that is Tapan Kumar Das and another. Commissioner Cuttack Municipal.
Oh, that was against illegal mining.
That is the second one.
That was different.
At page 7. Second one.
That was in the PIL. WPC number 8797 of 2004, along with OJC
Maybe
number
what it is,
671.
that ILR. 2012 to ILR.
Right.
Which paragraph?
Well, it's kind of a glance with that. I'm straightway coming to the paragraph number 12, last portion. Therefore, may I read, my lords?
In case, there is one, in case the private tanks
Belonging to private individual.
lost its characteristics.
Page?
Page, my lords, 955. Start from 954 and then 955. Therefore, it starts from the word therefore.
Yes.
Therefore, the state government cannot absolve its responsibility to protect and maintain the water bodies.
Paragraph 12?
Paragraph 12, last portion.
Yes.
The finding. Therefore, the state government cannot absolve its responsibility to protect and maintain the water bodies even belonging to the private individuals. There is also big tanks which belong to various DTs and private individuals in the city, and the state government should come forward and protect and maintain the same also. Then paragraph 13. And the court laid down that principle at how it should be converted matters. And under what circumstances. Paragraph 13 last portion also it will be.
Yes, so in 14, there is a procedure.
Procedure adopted. And I pray either to maintain that permanent pond, my lords. Suppose they wanted to convert the pond. Let them follow the procedure. If the pond retains its character, it should be retained, my lords, in the interest of the public. Suppose, my lords, they wanted to convert it. That procedure to be followed. Not that without converting the same, they will go on selling portion of the properties for the purpose of homestead. That commissioner also has referred to 5 to 6 LDs have been executed in respect of small portion of the areas, converting it to, so use it for a homestead. That is my limited case is.
The land might have been sold, but for the purpose of homestead, is it there?
Yes, that is what the municipal commissioner referring to the report of Tahsildar stated.
Without changing the kism of the land, how can construction be done?
The allegation, Your Lordship, there is no construction at all.
Oh, then we can direct that if there is any construction on the land recorded as pond, it can be demolished.
If they have done anything illegally, Your
It can be
Lordship,
demolished.
if they have done anything illegally, I am ready to that.
If that is so, my lord, if they will retain the pond as it is, my lord, I don't have any.
No, if they followed the procedure for changing
If there
the
is no
kism,
problem, that is
then-
done. I cannot stand in that way.
I think if my peruse my counter affidavit, I have specifically stated that till date I have not taken.
No,
any
but
step.
Mr. Counsel, the land is in the nature of Jalasay as mentioned in the
Record of right.
record of rights. It is not in dispute.
My lord.
According to you, it has lost its character.
My lord.
So you could have approached the corporation or whosoever in accordance with the direction issued by this court
My lord.
for changing the nature of the entry.
My lord.
Why didn't you do that?
My lord, 2011 entry model is operating. 2011 itself an entry model is operating against
What
me
entry model?
to the maintenance status quo as on date. And even if I made an application, they will not entertain it.
Why will they not entertain?
So then the entry model you will not.
No.
No, you could have brought it to a notice that this is for this purpose. If that has been done.
Then in my limited knowledge, also I should have done that. In my limited knowledge, I have not done that.
If that will be done so, my
Yes.
lord, I think I don't
Can
have
they
any.
do it?
Any problem.
Can they? If they do, then will you decide?
No, my lord. Question is, my lord, Kapan Das came judgment. Before that, actually, all these conversions have taken place. So now, actually, your lordship will decide whether, if suppose subsequently they have to again apply for reconversion.
No, have you stated that conversion has
No,
taken
no, I
place?
have given the report, my lord.
Where is your affidavit?
Your lordship may
That
see page.
conversion has taken place before that?
Your lordship may see page 8 of my affidavit.
Where is the affidavit?
Page 8, my lord.
You have not filed any counter affidavit, only
Counter
a-
I have filed, my lord.
26/10/2022.
My lord.
Counter affidavit filed on behalf of?
There are two
Municipal Corporation.
counter affidavits by
Opposite part
OPID
number
for
5.
26/10/2022.
Yes.
Your lordship may see the inquiry report. All conversion took place before 2005.
Conversion had already taken place.
My lord.
Then?
OP5 is not the municipality, it's
The
opposite
land has been sold and
private
it has
party.
been recorded in their name, my lord, private person.
Therefore, it had lost its character. This is
My lord,
their stand.
it has lost its characteristic.
So therefore, they could have applied for change. And it is not your case that it is in the nature of pond.
No, it's not in the nature of pond, my lord.
Then what is public
And
interest?
Your lordship may see, my lord, he claims that he is a public spirited person.
His,
Let us see this counter.
My lord, he claims that he is a public spirited person, my lord. Regarding all ponds in Berhampur Municipal Corporation, the matters were before the NGT, my lord. it started from 2015 and it continued till 2022. All the ponds were in under Berhampur Municipal Corporation were renovated. And he claims that he is a public spirited person. He did not appear before the NGT.
I don't know that.
How will you know cases are there before the NGT? Have you given
No,
public
no, he
notice?
knows about only such ponds which are there near his house.
It was coming in the newspaper.
And because
It was
he has the easy access to
Is the access and
some
see.
frivolous public interest litigation.
May I pay minutes, page
All
number
right.
8 of that.
So
page number-
frivolous writ application.
May I pay
Mr.
minutes, page number 8 of that
We-
counter minutes.
Oh.
Well, kindly have a glass to that. page
Yes,
number
we will see every aspect.
But Mr. Sahu, in your affidavit, have you stated that the kism of the land has been changed? You have
No,
only stated
they
it has
said-
been transferred.
No,
no,
they say
it's
a
not-
portion has been transferred. They say it is Jolasar.
we have relied on the inquiry report of the Tahsildar
No, no.
because corporation has nothing to do with the kism of the land, my lord. It is a private plot. Had it been a pond on the corporation, my lord, we have made inquiry or would have been answerable to the.
I'm only referring to Annexure B by 5. Page 8. Page 8.
All ponds in Berhampur municipality have been renovated, my lord.
Well, kindly visualize one thing. Page
No, you have
8.
stated paragraph 6 that
Fine.
the pond is polluted, muddy and unhygienic.
That was the inquiry report.
Yes.
I have stated that was the inquiry report, my lord. It is a
Yes.
private pond.
Yes, yes.
My lord.
You are saying the pond is
My
there,
lord.
it is in bad condition.
That was the fact, my lord. When inquiry was undertaken, that was the fact.
Then, my lords, the
But the
provision of
question is
my lords-
actually he could have been before the NGT.
NGT.
From 2015 to 2022, 7 years, this matter actually went on.
Well, I'm pointing out. Jolasar. But may I only
No,
point out
the-
one thing, my lords.
in the
That
ROR
council
Yes,
is-
but not at the same time.
And my lord, the ROR I have given in the name of those subsequent purchasers. So they have converted it.
Where is it?
I have given all page, starting from page 9 of my counter, my lord. All ROR copy I have given.
So tell us, what is the kism of the land? Show it. Jolakara.
Jolasar.
Jolakara.
Jolasar.
Jolakara means water tax.
Jolasar. Page 7.
Page 7 of what?
Page 7 of the counter. Badbazar, Khata number 190, plot number 1679, 1 acre 6758, Jolasar 1, such and such. My lord, then my lord, the next page is very important.
This is
Jalasa has recorded in ROR.
kism is Jolasa. It is not that they are converted.
No, they have not.
In my affidavit, I've given correct ROR copies. If you lordship will want to peruse that. Those ROR copies where that's been converted from Jalashaya to Gharbari.
No, that
So are you opposite party number 5?
My lords.
And the municipality is also opposite party number
What
5?
happened, initially municipality was deleted from the petition, your lordship, but subsequently they were added. So they should be added at OP number 6. Instead of OP number 6, they have added OP
But
number
in the
5.
read petition, it is OP number 5. So I filed the
That is where
counter.
the confusion.
Yes,
So
sir.
opposite
Well,
party
sir,
number
only
five.
I will point out only one page. Well, it's page 8 of the counter filed by municipal corporation.
That is there.
They refer to the report, well, that is the inquiry report in this case.
I want to dismiss this petition with
These are
exemplary
the-
cost. because this is motivated. Not a public spirited approach. You are individual.
I will point out thereafter, my lords.
We will decide. We will decide. We may impose. See, we need to discourage frivolous public interest litigation.
I 100% bow down, my lords.
You should agree to it.
My lords.
You should agree to it.
My lords, I 100% bow down that. Only thing is that, my lords, I am to satisfy actually what is happening and what is being told.
Yes, yes.
My lords, that is a kind of a glass
that we will go through the pleadings.
The page
We will
8,
take up the
my lords, kind
matter.
of a glass to
We
page
will
8.
take up the matter on the next Thursday. We will ourselves go into the pleadings because of the nature
my
of
lord.
conflicting stands which the petitioner and the parties are taking. And if we are not satisfied, we shall impose exemplary cost that shall be for others also to learn.
My lords, may I submit, my lords, only one thing, my lords. Before that, I will only point out only one page for my lords' consideration. One page.
2011, you got an order of status quo. This matter is pending.
Well, I have never taken time, my lords. That all throughout months I was ready. Excepting last day, because I am suffering from dengue, that is what I have taken time. Before that, I have not taken any time.
All right, next Thursday.
There's only one submission which I will permitted to make.
You please give your written notes.
You also have proposed a query whether I have considered anything. You should kindly see page 8.
We will see next
The
time.
inquiry report states I have
We
done
will
nothing.
see next time, Mr. Counsel.
Pilots.
See, we are required to go through carefully the stand which the petitioner is taking, the corporation is taking, and you are taking.
I bow down.
So PIL pending since 2011 in respect of a small chunk of land.
My lords, only draw my lords' attention to only one page.
We
my
will
lords.
see everything next day.
My lords, the page 8 of the.
We will see everything, Mr. Counsel,
We have
next
to
Thursday.
read everything because sometimes people don't point out relevant things. That is the sad part. That is why you have to see everything.
Item number 11.
My lord, item number 11, we are filing the counter affidavit today itself. We'll be filing in the course of day.
We are rejecting your counter affidavit. We will not allow you. Why are you filing your counter affidavit today?
Lordship, the only predicament is the petitioner has made the chairman and the headquarter as the parties. That is why it is.
No, when did you receive notice?
Notice was issued in the year 2022, Your Lordship. To us.
22?
Yes, Lordship.
Who are you?
I'm Indian Oil Corporation, Your Lordship. The petitioner did not pursue the matter, and in the year 2022 only notices were issued.
Yes, but in 1/8/2024, you are granted time to file counter.
Lordship,
Again on 22/8.
Lordship, today only we are filing the counter affidavit. Lordship may accept it today only.
Where is the counter?
Lordship, today in the course of the day.
Where is the counter? We file somewhere.
But today we will be filing it, madam. Lordship may accommodate me for this last time, madam.
Why is this matter pending since 2011?
Lordship, the notice.
Just let the petitioner.
In the meantime also, twice, thrice this matter has been listed and my lords are specifically directed. If at all in the meantime, since 2011 it is pending and even the representation is pending under Annex 4, that is not being disposed of. And last 3 occasions they are taking time, even as of now also they have not filed the counter, nor they are before your lordship.
But Mr. Mahanti, how can you say that when you did not file requisites for 10 years? How can you accuse the opposite party of anything when you did not file the requisites for 10 years? That is the
Well,
order of the
order
court
was
passed
on
on 13/7/2022.
13/7/2022.
Yes. You have filed this writ
Matter had
petition in
and
2011.
fresh notice, my lord.
Please.
To the OP number 2 and 4. Because 3 was the collector.
For over 10 years now, requisites have not been filed for service of notice on opposite party number 2 and 4. Mr. Mahanti, learned counsel for the petitioner, seeks one more chance. Fresh notice to opposite party number 2, returnable within making it returnable within by the next date.
So what is the case? What is your case?
Case is, my lord, the land is acquired for the purpose of refinery project of IOCL. So I being a land user, I am very well coming within that purview of the policy of 2006. So I have undergone training also that I have applied for my observation. They have not done it, and I have also filed the representation. That was neither it has been considered nor my case has been considered. But others are getting the job because of they have acquired the land for the inhabitants, and my land has been acquired.
You want job?
Yes.
Where is that policy? Where is that policy?
Policy, my lord. Policy is, my lord, at Annexer 3, page 19.
File your affidavit.
Lordship.
Relevant pages, page 25 and
Let the
26.
counter affidavit be filed on behalf of the, which opposite party?
2 and 4, Your Lordship.
2 and 4 by tomorrow?
By tomorrow.
This case on next Thursday.
Can
You
it be
considered
done?
have you considered his case?
Lordship, the only, as per the counter affidavit, that the instruction I have received, only the displaced persons can be considered for employment and can be assisted for employment. And the land users are not considered in terms of.
He is not a displaced person.
No, he is not a displaced person. And for second thing is 2006 RNR policy is not applicable to him. There was another policy, 2002 policy, that is applicable.
All right.
Because of the date of acquisition.
Lordship. But can it be taken up on 19th? I have a personal difficulty on next week, my lord. At 19th.
19th.
Sir, copy by tomorrow.
Lordship, I will.
The copy by that
I will serve copies.
Response to this.
Lordship.
Item number 12.
May I please, Your Lordship? Here the present petitioner is claiming the revised scale of payment, which has not been paid to the petitioner, my lord.
What amount? What?
Revised scale of pay, my lord, with effect from 1/1/96 to 39 to the 2, my lord. So last, I have filed an additional affidavit last occasion, Your Lordship directed how it will meet the limitation. The last occasion, Your Lordship directed after 8 years I have approached, my lord. Now, Your Lordship, I have filed an further affidavit, my lord. So that has come, Your Lordship. I'll see. 2011, the government has.
When did you file?
It is filed on 3/9/2024.
You could have filed it today for getting further adjournment.
No, Lord, I have filed. It is on the record, man.
It is on record.
Yes, ma'am.
Additional affidavit.
Yes, ma'am. What did you say? Well, file it very well.
When did you file?
It is a court. It has not come.
Oh.
3rd September.
Yes, ma'am.
Yeah. Yeah.
You've been, Your Lordship, already solved. Copy already solved, my lord. Unless it is solved, it cannot be accepted by the.
No,
this.
affidavit, nothing, no copy has been served.
They do.
For reproduction, unless we file, they will be what.
No, you also in the any affidavit, my lord, any documents, my lord. Yes, ma'am. No, they will not accept in the risk.
You must be having a receipt with you. Then the date of.
So your Your stand is that it is,
A continuous cause of action. Yes.
that we have understood. That since you were entitled to get that amount in 2003, that was continuous cause of action, and therefore you could have filed any.
Because they have already issued letters to the different colleges to what is the financial border matter. That is the under process, my lord. It has not been sanctioned.
Oh.
Had it been sanctioned, then matter would have been different, but the area will come. Because till date they have not sanctioned.
We are not satisfied.
Your lordship, I have filed two decisions, my lord. I have brought.
Yes.
That is 2013 once. Basis, my lord, 353.
Yes, please.
Page 30. Both decisions I have given, my lord. M.R. Gupta, Darasan Singh.
Huh?
Both decisions are cited.
So you were entitled to what amount?
Because 1196.
Mr. Counsel, you were entitled to what amount?
Revised scale of pay granted under the ORSP 990.
What was the what amount? Have you calculated?
No, I have not calculated.
And then the mistake in.
Because of similar.
The mistake in the affidavit in paragraph 3. When they issued letter in 2011, they could not have asked for area revised pay from 96 to 2011.
Yes.
2022.
This is the type of error, madam. I'm sorry. 02, madam. 2005. That type of.
Yes. Where is that decision?
Yes, madam. I'm giving. I would say.
Yes.
Your, my lord, our High Court, my lord, 226, my lord, under Article 226, limitation is not applicable. Your lordship, I have given the.
Mr. Counsel, why are you making this submission? Are we saying that limitation is applicable?
No, your lordship, last occasion, lordship directed to.
Yes.
Yes, but that is why I am saying, I have a hard at length, my lord. Last occasion, your lordship, under rule 9174 rules, so all are eligible, my lord, to get the benefits. Your lordship, to that extent, I have clarified, my lord. Only with regard to limitation, that is your lordship.
Can we say that law of limitation will apply in proceeding?
No, your lordship, kindly see the last order. I may be misunderstood, my lord.
Last order, we have recorded limitation.
Yes, yes.
Limitation.
Delay.
Let us see. Delay is different thing.
Your lordship can see the order. We are of the prima facie view of the writ application challenging the resolution dated 23/2003, so as to claim the areas of salary for 1196 to 30th/9/2002. Filed
Well, you're not understanding, Mr. Kuntia. Have you mentioned the word limitation anywhere? We're talking of the delay.
Delay.
There's a difference between delay and limitation. Limitation is a fixed period.
There will be no delay. That is, I have filed the.
Say, online
That-
printer.
M.R. Gupta and Taresam Singh, lordship.
Yes.
Item number 13.
As observed by your lordships, I have approached them, the corporation on 29th, my lord. They have given me a letter yesterday, my lord. I couldn't put it on record. They have given me three options. One is that you wait till kiosks are constructed near where I am working. Two shop rooms.
Shop?
Shop rooms, first floor, second floor. I am a vendor, street vendor. Question of paying rent, use rent for shop rooms doesn't arise. Then third is about vending pindi. That is in Ghatia for sale of vegetables and fish and other things. that is not, and they have not told when it will be available. The petitioners were suggested to apply for shop rooms available in BMC. And thereafter, their allotment of shop rooms shall be considered on the basis. Has your lordship got it? Can I pass my hand?
Let us understand, yes.
Well,
but according to no option is acceptable to you, no offer is acceptable to you.
The last offer is acceptable, but when they will give, the petitioner are also suggested that they may wait for the vending kiosk of BMC, which will be constructed for street vendors on availability of feasibility land in nearby location.
That is very difficult. So therefore, what
that is uncertain.
Therefore, please, you should accept an offer. In fact,
the shop room they will consider along with other eligible persons. Shop rooms, I am a street vendor, market complex shop rooms. Can I afford it?
Shop room. They will be required to pay.
They have not stated anything regarding the amount. I have to ascertain. But that will be quite high.
What is the
rent? The shop rooms rent would be around 5,000 to 6,000 a month, because it is constructed building with roof. And here, my lord, these petitioners are occupying this municipal corporation area from 2011, not paying a single rupee to the corporation.
No, but as per the street vending rules, they have to pay some license fee. I don't think they are supposed to.
That also they are not paying.
So that if you give them some identity card or something, identify them, then they will.
That they have. Otherwise, how we collected 5,000 rupees from each of the vendor for the purpose of construction. But after the smart city scheme came, no construction was permitted, because that area was taken as a buffer state by the Bhubaneswar development.
That is the kiosk.
And in fact, my lord, these people are occupying an area 200 to 300 square feet each. It's very interesting. Normally, vendors are to occupy.
Now he has completely made a U-turn. Last time he told
me by sending a commission, these people are constructing, having fabrication unit, cycle supply unit, motorcycle repairing shop.
They have allotted 7 into 7 feet.
No, that is what he's saying. 7 to 7 feet has been allotted, but then in reality they have occupied more space.
Yes, that area. This totally.
Kiosks will be how much?
No, once you are given kiosks, there will be small ones.
This will be 8 to 8 feet. 8 to 8 feet. 8 to 9 feet, 8 to 8 feet. That will be.
And for that, we have given them money. They have given some of us. But
and there is no land available to that vicinity.
You are now telling that nearby location you will.
My lord is well conversant to the locality. The Rajman Square is totally jam packed. There's no space at all.
ରାଜଭବନ ସ୍କୋୟାରରେ ଆମେ ବସିଛୁ ନା କଣ?
Are just like that square ମାନେ କଣ ଖାଲି ଛକଟା ଗୋଲେଇଟା ନା I don't think they may either wait till we let them inspect the shop rooms by not buying them. Let them see. It is near the estate assembly.
ଯାଇ ହବ ଯେମିତି 10,000 ଟଙ୍କା ଲେଖେ ମାସକୁ ଭଡା
ଏଠି ମାଗଣା ରହୁଛନ୍ତି 11-12 ବର୍ଷ ହେଲା।
That is the scheme. That is the scheme. Because they can't afford, they do it on the street. But they need space.
My lord, the amount of money they are adding lordship would be bad. Almost 100 feet, 200 feet, 300 feet.
I don't understand why my senior friend is jealous about their earnings. And they cannot be compared with your earning. You should not be jealous of their earning.
All right, we will take up after.
Item 22, Mila. Because all the seniors are there. So with it's a public policy basically. So that was under challenge. The single judge order is against them.
22
so
is what?
22, a batch of heat appeals. Medical shop matters.
2 p.m. matter.
Yes.
It was specifically fixed at 2 p.m. So there may be some government level they are discussing over it with the change of government. So your lordship may grant me some reasonable time to work out what is the policy, revised policy they may bring out. So let it come, some time may be given, reasonable time so that they can work out.
A 24 hours medical.
Yes. At least, my lord, 6 weeks time may be granted so that they can work out in the meantime.
Then you will have to file an affidavit. We will grant you time. We are adjourning for a week.
Lord, affidavit.
Affidavit in the sense that you are reconsidering the policy.
No, that is exactly not the. I don't know. In the morning only they told me.
Therefore, see, since 2015, they are continuing on interim orders.
Interim order, right? I know. I have gone through the file.
If you say on affidavit that the government is reconsidering this.
So then in that event, your lordship may call it on because.
Otherwise, see.
1 week after, next week let it come. Or after 2 weeks, 2 weeks. 2 weeks, let me consult with them.
Of Advocate General. Let these matters be listed on 2 weeks to be taken up at.
Can it be 3 weeks?
No,
because the assembly is going on. No, 2 weeks, 2 weeks. 2 weeks. No issue.
2 weeks. Sorry. The interim orders. 2 weeks, so as to enable him to seek instructions as to whether there is any proposal to reconsider the policy.
Not exactly reconsider, your lordship may not put that word because I have not discussed thoroughly. I just got the instruction in the morning that they may.
Exactly, if there is nothing.
That's correct. Because there can't be any concession by me. I can't do that.
Whether there is any policy.
That's correct. They are reviewing the policy, my lord. Your lordship may put it like this. They are.
Proposal to give the policy which is under challenge in the present batch of writ applications.
It appeals.
Writ appeals.
As usual, ballot in favor.
As usual, that has been done.
They have been enjoying that since 15 minutes. It's a policy.
It's
I know. I just now, I didn't have the occasion to go through the video.
Health policy has to be changed. Excise policy they have changed. This is one of the health.
No, has to be changed. You can say that. You can dictate the government what policy will be taken. That's not your prerogative. You have already lost in one forum, so that the government may.
Yes.
I may be pardoned, my lord. In item 46, I have informed, as directed by my lords, I have already informed my respected senior Mr. Rautrai. Very small matter. And considering my humble prayer, my lords have been pleased to. Very only
Mr. Biswal.
No, not you.
My lord, Mr. Tripathi, my lord, and 46.
Lord, just wait.
Sorry, I did not see you, so I was asking Mr. Biswal to inform you. Sorry. Thank you.
In that matter, I am filing a counter. Maybe counter may be filed tomorrow. Let's call it next week so that.
Yes, Mr. Tripathi.
My lord, may I prefer fixing up a particular date and time?
Yes.
Yes, please.
We admire your perseverance, Mr. Tripathi.
Obliged, my lords.
What is this matter about?
It's a matter.
This is a very small matter.
Please wait.
In this matter,
Please wait, Mr.
actually,
Tripathi.
yes.
It is relating to appointment of managing director in Odisha State Cooperative Bank. State Cooperative Bank. Odisha State Cooperative Bank. In fact, an appointment was made which was first by this honorable court. Then this honorable court directed that that managing director should hand over the charge to the register. And register is continuing as managing director till date. In fact, it requires a NABARD and the Reserve Bank of India, they have to be consulted and approval is required. That bylaw is required to be amended. That is why there is some little bit delay.
That means till today, nobody has been appointed.
Register is still continuing as the managing director. That is the problem.
One of the cases, I had also heard one of the cases, but maybe different cooperative bank.
This is one case where he was removed, subsequent.
Yes, same matter.
It is this case.
Only the judgment.
Yes.
The only grievance of the petitioner in this matter is that in view of assumption of charge by the registered cooperative societies as the managing director of Orissa State Cooperative Bank, that is creating a vacuum and in a statutory provision on section 70 and 112 of the OCS Act.
To take all possible, whatever is possible to complete the process so that advertisement should be made to give appointment to the managing director. In fact, I am filing an affidavit to that effect also.
Mr. Rautral and senior counsel appearing on behalf of the opposite parties list this matter on 1 week.
1 week.
1 week. Not 1 week.
Not in between 15th to 21st. I am not there. Either also keep it to
22nd.
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 It's 23rd. 22nd is a holiday. Sunday. 22nd is a Sunday.
Oh.
23rd.
23rd.
Yes.
At 2 p.m. may I prefer to
23rd.
20. This matter tomorrow. This matter on 23rd. Since Mr. Rautrai and senior counsel appearing on behalf of the party number
3. OP number 3.
States that a counter affidavit in this case shall be filed by tomorrow.
By Tuesday also. Monday already, by Tuesday.
By Tuesday. The time in the meanwhile may be utilized by learned counsel for the petitioner to consider the said counter affidavit and file reply if so required. All right.
may I prefer fixing up at 2 p.m. after launch.
Just tell us on that day we had your case was at item number 46. We have taken up your case. That day also you just tell us we will take up.
DPO.
Yes. Yes. Yes.
Sir, I am completely at your lordship's mercy. My lord, your lordship.
No, you may be at your lordship's mercy, but finally we have to resolve it.
That's right.
Resolve it.
My lord, your lordship will kindly see. But now this verification and other things, it sounds odd, my lord. But in fact, in 6483, my lord, they admitted and gave 25% out of 77. Then they told that we would construct 52 more number of kiosks and allot it to the petitioners. Then they didn't do that and wanted to evict us. Therefore, we came in 6483, my lord.
6483?
Of 1995. Then they told that we'll claim it, verify and give it to them. Didn't do it and wanted to evict. Therefore, we came again in another writ application, 11611 of 1996, my lord, and your lordship passed that interim order. In spite of the interim order, they wanted to proceed, and your lordship issued contempt notice. And on the threat of contempt, they told that if you withdraw the writ petition and the contempt petition, within 15 days, allotment orders will be issued. Then we withdrew, my lord. Then, my lord, they told that initially they took 5,000. They told now you have to do it at your own cost. That also we agreed, my lord. BDA approved the plan. Then, my lord, they further 3743 was filed challenging the action of BMC. But when they told that now you take back the money and it will not be given, then there also we got a stay. Then they told that now you construct it at your own cost, and the writ petition was permitted to withdraw and to file fresh writ if the same is any cause of action exists. Then again, Lord, thereafter this writ application has been filed again, and attempt on that it was needed for by constructing of the flyover. Flyover have long been constructed, since long has been constructed. But now they say that there is no space available to construct the kiosk. Your lordship was a prima facie view that since we have been admittedly doing our amending there, so Street Vendor Act will be applicable, and wanted to resolve that issue by telling them, till now they have not enumerated, they have not prepared the list of the street vendors, they have not given the identity card, and now they come out that so far we are concerned, these 52%, they are telling out of those who are surviving, because they are telling that you take either the shop room or the pindi, or you wait till kiosks are constructed and then we will. But we are there. And the act says that.
So if pindi is given to you, then?
Pindi, my lord, that would be a square size thing to put vegetables or fish.
No, instead of sitting on the ground, you will be provided some sort of platform. Oh, say that it is at a distance away. Say that.
That is.
Otherwise, you are not supposed to be provided only any facility, only space.
Only place.
This they want to give you.
That is space with our cost we will construct.
No, construction.
No, you can't construct.
No,
you can't construct anything.
No.
Street vendors, no question of construction.
If they are going to construct kiosk, for which 5,000 rupees is lying with
Kiosk
them.
is temporary. It can be removed.
We have surrendered. We have already refunded that amount of 5,000. They are not collected.
We have not taken.
Yes. And now, my lord, Now, my lord, from 2011 till this date, 15 years, they have not paid a single pint to the corporation even because, my lord,
That they will pay. That
You
is,
calculate will pay.
see, that is not very important thing. The question is whether
It is only
how should
license
they be adjusted?
my lord, the options we have given, my lord, either shop room or the pindis that is coming in Atikia.
How much? How much? So you will charge 5,000 per month for them from them.
That is so far the shop room is concerned.
Shop room is concerned.
He is
So
not
how many
sure.
shops do you have?
So far the pindis are concerned, my lord, it will be hardly 300-400 rupees, I think, per month.
How much shops do you have?
Shop rooms, my lord, we are, as per my information, 26 shop rooms are there.
So all of them cannot be adjusted.
My lord, 25 are there. The petitioners are 25.
25.
Yes. All can be accommodated.
So only 5,000 per month.
5 to varying it, but my lord, there is a calculation here. 5,000 to 6,000 in between. Exact amount I can't say because it differs from room size. 10, 12 size, 10 by 10 size, 12 by 12 size. It depends on the room.
No lump sum deposit.
No, my lord, lump sum.
Or something.
Lump sum, my lord, I have to. There is no security money. I don't know, but so far the calculation is concerned according to the room size. It is to be calculated because 10 by 12, 12 by 12, 12 by 15. These are the variety size.
Your lordship carefully reads that letter. That letter itself is subject to eligibility, verifying the condition in accordance with the rules.
That we will see, Mr. Mohanty, but if you get
Yes.
if you get a shop, just
no.
think of only because of this.
No
that
issue.
It is not easy to get a shop room. And if you get,
that is near assembly.
even if you are required to pay this 5,000, that can be managed. You are
I'll ask them.
so this is an opportunity which these persons
No,
must avail. Otherwise, they will remain on streets.
But at least let this matter be concluded in this bench.
Yes. So therefore, you will be this benefit you may not get elsewhere.
Constructed building, my lord, is not a temporary one or an open plate. And my lord, justice.
Lifetime opportunity.
I'll get back to your lordship's
Please
next
do.
week.
And if any financial assistance is needed, that can be seen if they require. If they don't require, they should. Otherwise, if some loan, something.
I will ascertain them and get back to your lordship.
Court's suggestion would be that these petitioners should grab this opportunity.
But the third option is really the best, that they will construct kiosk and give us to us.
We can't give a guarantee which area that will be. That is the problem.
Therefore, see, get the present, which is available. Don't lose the chance.
Right, your lordship's put it on 24th.
24th. This matter on 24th. This is
In the meanwhile, my lord, they may apply.
26. List this matter on 26 within first 10 cases, so as to enable and senior counsel, learned counsel appearing on behalf of the petitioners to seek instructions from the client as to which of the offers given by the corporation is acceptable to them. We'll see.
Mr. Mahapatra, you also get specific instructions regarding the shops, whether these will be given only to these petitioners or they will apply along with others and they will be considered.
I'll get it. I'll get it.
And the rates also. I will ascertain the
And
rate.
let us be clear on not only rates. If some one-time amount is to be paid, it may be difficult for them to pay.
That is a commercial complex area near this
Once they know, they can take a decision. What cost they
See,
can incur.
sir, we secure social justice also. So we will have to keep that in mind, that these street vendors They are being taken to shops. So it's a kind of upliftment.
Upgrading
that- And for that, you may have to relax some of your requirements
I'll find.
and help them.
I'll get back, man. I'll get.
The interim order to continue.
Interim orders are continued.
My lord, I have got another matter 70. Can it be passed over? To just
Ask your junior.
I'll ask, my lord. I know. Another matter was also there after lunch. That is how, I mean, they have asked there a pass over.
Only.
Your my lord is a case where the petitioners being the president and secretary of the association has filed seeking a direction to the CDA, my lord, to construct the sewage and
It will
drainage
go
system.
before that bench.
My lord,
Green bench.
no, it is not a PIL, it is personal interest, Lord.
Personal interest.
Personal interest. Because
Personal
land is allotted to the association.
So why has it come in before division
No,
bench?
that is relating to my lord. You lordship may kindly see for a moment.
Yes. That is relating to providing the storage system. That is also considered by that bench. Today this bench is.
Your lordship, it is not correct. Your lordship may kindly see for a moment. Just let me. Your lordship may kindly see annex
It's not a PL, then why?
the map. Here, towards the eastern side and southern side, there is no storage system and drainage system. The buildings which have been constructed by the employees, each employee of the association, now it is without having storage line. You lordship may kindly see this honorable court by its order dated But 14/8/2012. Part this order, London Council, Mr. D. Mahapatra, appearing for the Kotak Development Authority, is directed to file an affidavit of the Vice Chairman CDA, opposite party number 1, with reference to the fact that the area involved in this case, after being fully developed by forming storage system by the CDA, has been handed over to the Kotak Municipal Corporation. You Lordship may kindly the affidavit filed by CDA. You Lordship may kindly see the para 8 of that affidavit.
That means in 12 years, the application is.
Around 7,30,000 have been sanctioned for the for construction, but it is yet to be constructed. You Lordship may kindly see para 8 of the affidavit filed by the Kotak Development Authority, opposite party number 1. I may be permitted to read that. It is further submitted that in consideration of the problems faced by some of the allottees under the society, and to avoid any stagnation of sewage water, CDA is constrained to develop the additional sewage system, incurring additional expenditure, and for which it has proposed to spend a sum of rupees 7,30,200, and the same was placed before the authority of CDA for approval by item number 18/94. And authority approved the proposal and resolved to get the work executed by CMC with placement of funds as estimated, since sewage system has been handed over to them. In order to ensure smooth execution of the work, CMC was requested to develop additional sewage system at the cost to be borne by CDA, and accordingly the secretary in its letter number such and such 7385 dated 8/4/2011, your lordships, apprised the matter to the CMC. Subsequently, the vice chairman in letter number such and such also requested to CMC to prepare the estimate for the work and intimate the undersigned so that the amount approved can be transferred to CMC for taking up the work and to complete the same within 2 months. The affidavit is filed way back 2012, your lordships. Till then, the sewage line and drainage line has not been constructed. And it is stated before lordships, it is handed over to CMC. Thereafter CMC has said it is handed over to other authority. By that way, it is continued. And there is a condition in the allotment letter, my lord, the individual cannot make a storage line and latrine also.
Why is it before the division bench? If it's not a
It,
PIL?
it, it was assigned before the earlier. It was assigned before. It was the assignment of.
This should go before single judge.
No, my lord, it is the assignment of division.
Under what heading?
My lord?
Under which heading?
It was assigned earlier, my lord.
No, earlier it was listed, you
It
are
was
right.
assigned before the division. It is continuing.
Now
It is coming under the old matters, lordship. Your lordship has.
Old matter, all old matters are not
This is
coming
also
for the division.
coming under
Why?
the.
On the old matter that has been listed, but it has to be the assignment of the division bench. That is what we are saying.
That my lord, I have to
Old
verify
matters
that.
assigned to some other court, division
For
bench.
that, you'll have to seek instruction.
No, my lord, then my lord, it was that has not come to my mind that it is not assigned to your.
All right. Yes, you're for?
Well, I am for Cuttack Development Authority.
Yes, what problem do you have?
Yes.
What issue? Why you not, why are you not
The fact
constructing?
remains, my lords, a piece of land was allotted for group housing purpose. They constructed their houses, my lords, carving out that plot. Their duty is to connect that storage line to. They say that the storage line should be laid adjoining that their plot. I have given that sketch map what they exactly wanted. But in the meanwhile, pursuant to the direction of the Honorable High Court in OJC number 6721 of 99, all these facilities were transferred to municipal corporation. So again, CDA again will do the work. Thereafter, municipal corporation will again renovate this because it was old storage system. Now it requires renovation. That is what, my lords, we require the municipal corporation at once to do the work. In the meanwhile, what happened? The municipal corporation, the government distributed the work to be developed. Government required that this should be developed by the storage board. Then, my lords, Honorable Court directed to implement the storage board as a party. Storage board appeared. Storage board said that no, this work has been given to the WATCO. Now WATCO is to do it. So WATCO will do in respect to the whole total work, including this work. Now WATCO is to be made a party so that WATCO can answer and WATCO is to execute the work.
What is WATCO?
Water, that a company formed under the Housing and Urban Development Department. Water and
That sewerage board in place of that,
WATCO has come. That storage board has filed an affidavit here in this case that WATCO is in fact executing because government has distributed all these works so far municipal corporations. That is in respect and that municipal corporation in CDA, so far CDA is concerned, that will be taken over by the WATCO. That is the affidavit filed by the storage board.
But is from the very inception it has to be constructed.
No.
Let us try to find out how to move first of all.
Now, my lords, we are not disputing for the region. Maybe, may not be, but fact remains once authority has decided that all right, we have to provide that facilities.
So you are CDA.
We are CDA.
And who is for the corporation?
Corporation, my lords, the PIL bench is going on. I think, my lords, the PIL bench today is going on. No, corporation bench, Mr. Nayak.
No.
We are asking about CMC.
WATCO.
Madam, what is CMC, my lord? On behalf of Mr. G.K. Mohanty.
Yes.
WATCO typing Bhuya.
WATCO, Mr. Bhuya.
Madam, the government has handed over the project to storage board from 12 to 2013, my lord. Thereafter, it was handed over to PHUO, my lord, since 29 January 2020, my lord, in terms of resolution dated 10 September 2019.
Yes. So CDA has given it to CMC. CDA has given it to CMC.
CDA handed over all assets and liabilities to the CMC.
When?
Since
When?
It is the, I think,
2011, you lords.
2011.
It is a para 8 of the counter.
Since 2011, we have already handed over.
What handed over?
Well, the common amenities like road.
Common amenities.
Common
So
road, storage,
you
and
are
all
the
this.
development authority. So
We'll
your interest is still there.
We'll develop, our interest is there because what happens, my lords, the storage system, what my London friend required, it may not be required, but the authority once decided to develop this, it is the duty and responsibility of the Cuttack Development
Yes,
Authority
for
to do it.
CMC gave it CMC. What did CMC do?
Cuttack Development Authority is to, Cuttack Municipal Corporation is to execute that work. I have to hand over the money to them. In the meanwhile, what happened? Another concept has come. That storage board.
Sewerage board. This
Storage board.
This was done by whom?
Storage board mailers, that is under that's an organization under the Housing and Urban Development Department. it has to undertake storage development in respect of whole total CDA, including these work.
Sewerage board is exists.
Yes, madam, that is, they have appeared. They have appeared.
Sewerage board. And sewerage board thereafter what happened?
Well, storage board, my lords, while storage board is an operation, so of course, on the affidavit, on the basis of the affidavit I'm submitting, government, my lords, require that all these work, the developmental work to be distributed. Accordingly, they require this work is to be developed by PHED, Public Health Division.
PHED.
My lords. Thereafter, a decision was taken that it should be taken over by the WATCO. At present, WATCO is to take over this work.
WATCO. All right. So who heads CDA? Who heads CDA?
Vice Chairman, my lords. We have already requested, place the fund to the municipality.
Vice Chairman. Who heads the CMC?
My lord. My lord, the commissioner, my lord.
Commissioner.
My lord.
And sewerage board?
They are represented by
Managing director or what?
Huh?
Only director.
Managing director or director?
Managing director. Member secretary, your lords. Opposite partner force. Member secretary. Member secretary, Odisha Water Supply and Storage.
Whether there is any managing director or not of sewerage board. All right.
Member
PHED is secretary. Who is secretary or additional commissioner? Chief
My lord, Public Health Engineering Organization is headed by engineering in chief. Opposite partner 5. There was a discussion before the chief secretary. Thereafter, it was decided that it will be developed by WATCO.
WATCO is headed by?
My lord.
WATCO is headed by?
WATCO, my lord, right.
WATCO must be government.
WATCO, my lord.
Government company.
A company under the Housing and Urban Development, created under the Housing and Urban Development Department.
This writ application is pending since 2012. And relates to construction of sewerage and drainage line in the eastern and southern side of the plot bearing number 10-GH
10-1.
-1-GH-565 allotted to Cuttack Collectorate Employees Group Housing Cooperative Society at Sector 10, Markat Nagar, Cuttack. So stop. How many houses are there?
Lords, the scheme shows, my lords, that they have carved out this just a minute. I given that sketch. They carved out
Is it a high-rise building or different?
no, these are
plots?
all land are allotted. They are to carve out subdivided into plots. Plots. That is annexure B/2 to my affidavit. It will be around 50. It will be around 50.
Oh, that.
It will be approximately 50.
All right. The
different categories are there.
The plot under Cuttack Development Authority. So stop. It has emerged during the course of hearing of the present writ application today, and is evident from the affidavit filed on behalf of Cuttack Development Authority that the work of construction of sewerage and drainage line was earlier given to the Cuttack Municipal Corporation.
Was handed over to Cuttack Municipal Corporation.
Cuttack Municipal Corporation. Stop. Sewerage Board. Cuttack Sewerage Board. What is that
And
called?
that Odisha's
Yeah, Odisha Water Supply
And Sewerage
Huh?
and Sewerage Board.
And Sewerage Board was later constituted.
No, that was there.
No, that was
That was there. That was existing.
Sure. The said work was later handed over to the water soils from board. Stop. Further, further later, the PHED, full form PHED, Vodco was constituted later.
What was constituted later? This is the, I think that will help my lord.
13/3/2020.
This is the resolution of the government.
13/3/2020 was.
There the government for smooth execution of the work divided the works amongst the organizations.
In the year 2019, the Housing and Urban Development Department came out with a resolution regarding redistribution of work and responsibilities among public health engineering organizations, namely organization, namely
PHED might file an affidavit.
Among public health organization, Odisha Water Supply and Sewerage Board, and Vodco. Stop. The work is now to be executed by Vodco. This is your stand.
It's more not my stand, but the government has filed a counter. This is the counter. There they say that it has been handed over to Vodco. Government has filed this counter.
Now has been handed over to Vodco. Stop. Vodco in 2021.
Are you relying on this?
No, this because of this it has gone to PHED. Thereafter PHED.
Because here they say construction by one particular and then thereafter.
Yes. That is for repairing purposes. Whole total scheme should be repaired along with this.
Very inception it was not there.
Whole total scheme.
That is my.
This is after completion and commissioning, it will be handed over to Vodco.
After completion and commission, it is these all total projects are there. One part is not there. Whole total scheme to be taken up as a whole, and whatever amount spent will be spent for that purpose will be handed over, so that the gradient and everything can be maintained.
The fact remains, however, that despite pendency of this writ application for more than a decade, the work has not started yet. No work started?
No.
Stop.
What in one part work is executing the work. No. Not your work, but in respect of CDA.
In respect of work has not started yet. The concerned work has not started yet. Stop. Next, in such view of the matter, we direct that let who heads PHED?
PhD engineering, PhD superintendent engineer, I think.
The secretary PHED, State of Odisha Department, Secretary PHED, convene a meeting within a week
Engineering.
Engineering.
Meeting.
Secretary-
Secretary
is not a
secretary
party.
convene the meeting. PhD must be having secretary.
Housing and urban.
Urban housing. Secretary, urban and housing
Housing and
department.
urban development, HRUD.
Government of Bihar, Government of Orissa convened a meeting of meeting to be meeting of the vice chairman within a week of vice chairman CDA meeting of the following authorities colon dash the vice chairman Cuttack Development Authority comma vice secretary. Let them feel the pinch. The managing director, the commissioner. So who is commissioner CMC?
My lord.
This VC and commissioner CMC one person.
VC.
Vice chairman,
He's
the
functioning as
commissioner municipal corporation is presently functioning as the vice
All
chairman.
right. We don't know. Commissioner CMC, managing director severance board जो भी है and managing director Watco. First off, the meeting shall be chaired by the secretary.
Secretary Housing and Urban
Development.
By he is the senior most person.
Well,
He is the senior.
Chaired by the secretary. So and so. First off, in the said meeting, the issues which have arisen in the present CD shall be addressed. First off, they will be required to come out with they will require to resolve the issue to ensure that considering the public interest, the work of construction of sewerage and drainage line is started within a reasonable period of time. First off, list this matter on 2 weeks, and the secretary so and so will be required to file personal affidavit. They can make slight changes in the this thing.
What is this OSIP Cuttack? In this notification, there is a reference to.
Another organization, probably another organization I have not.
Odisha integrated sewage implementation problem.
Number of organizations have come up. That is what it was required to be distributed.
Municipality has filed the affidavit giving a notification, and only repairing. Only
All right.
repairing, subsequently it has.
All right, we will monitor.
Deep low.
Item number 15.
I am asking for the opposition. Pursuant to my lordship direction last week, the copy of the additional affidavit has been served on me. I need some more to make it like that.
Is he enjoying the situation of pendency of the
Sound.
Yes, what do you want?
I want 2-3 days time, more time, I find reply to that affidavit.
When was that file?
The appeal they have served 2 days back.
Have you filed your affidavit?
Petitioner has filed their affidavit.
Whether you have
Not
filed
on-
your. No, but it is not there. When did you file your additional affidavit, Mr.?
Sir, on 27th of August, 27th/8/2024. 27th August we have filed.
The petitioner is said to have filed. And right.
No, nothing in the.
And we have served a copy of that also to the opposite party on 1st of September.
That soft copy. Copy I have received.
Copy of the additional affidavit said to have been filed on behalf of the petitioner has been served upon and counsel for the opposite parties. Full stop. He seeks adjournment to consider this said additional affidavit. Full stop as requested. List this matter on next week.
Item number 16.
Item way the old matters have it.
Then instruction that they have sent me instruction that financial assistance has already been given to all. But Lordship specifically asked me to give the details in what way they've been rehabilitated, Lords. So now they have been asking, Lords, I have asked them to give the affidavit regarding whether they've been, Lords, whether they've been resettled in their village or they've been given land for their settlement, Lords. But only some amount, 2 lakhs, 3 lakhs was given to them as compensation. That is not sufficient, Lordship's order, Lords. So some time may be given, Lords, I will file that affidavit. If not given, I will instruct them to do that, Lords.
Lord, as per my instruction, my lord, all the petitioner have not.
Mr. Samantre, could you repeat what you said?
Yeah.
Could you please repeat what you said?
Lords, they've been given financial assistance only. Because they were not scheduled caste people, they were not attacked by the
No,
villagers.
Fire.
And they were ousted from the village, Lords. So far their rehabilitation is concerned, Lords. You also wanted to know whether they have come back to their village, houses have been rebuilt, or they have been given some land somewhere, Lords, for their settlement. That was your Lordship's query. But they have only stated that some amount has been paid to them, Lords, so 2 lakh, 1.5 lakhs, and not like that,
That
Lords.
must be what they have done.
That they've done. But so far as whether they've come back to their house and they're staying in their village because they were
So that specific question was asked, why have they not answered?
that Lords, I want to put on record, Lords, by filing affidavit. If it has not been done, Lords, I will instruct them to do it and they're filing an affidavit. But only monetary assistance was not the Lords intention of the Lordships.
The
24
matter
1
was adjourned, Mr. All right.
So there in January, then.
January, your Lordship, sir, please to pass that order, Lords.
By way of last indulgence.
Yes, ma'am.
2 weeks further time is allowed for the estate to comply with the order of the court dated 22/1/2024. This matter on. Yes, 2 weeks.
Item 17.
Oh, you are seeking adjournment in this case.
I thought it was over. This was, the writ application was filed, and then subsequently it got dismissed for default. Then an application for restoration was filed, which was rejected by the Honorable Court on the ground of delay. Thereafter, the matter traveled up to the Apex Court. Apex Court, my lord, by its order, has restored the matter, writ application, but crystallized the issue to be decided, because I was also going through the writ application Mr. Develop. There are large number of prayers, but Apex Court crystallized it to one prayer. That is whether the petitioner is entitled to the rate of interest has been charged excess rate of interest in view of the fact that the petitioner has been order I have given earlier.
The order of the Supreme Court?
I'm giving to understand that it was filed.
Just remind me, we will have to registry somewhere. Let's do it properly.
No, the scanning page is not there. The scanning page is also
Which section does it? Which section does it? Why we are not getting the two things? One, the affidavits which are being filed are not being placed. Bookmarks are not being placed. Why is this happening?
not division, any document is there, they can take my affidavit dated saying that is there. What was the record? What was the record is a receipt. You have around item 17.
Yes, ma'am.
But there is one small mistake. The annexer. One will be two and two will be one. I want to.
Okay.
Notice.
Supreme
What is issue notice? Order.
Notice have been issued. Counter has been filed.
No, no issue.
One is to
notice
one
that
and
was
three
there, now
has
this is order.
1 and 3 has received it.
The Supreme Court is order I would complete the.
We had issued notice in this matter, if I remember. This is that matter.
Yes, yes. They have appeared.
Yes.
She is appearing.
Why do you say that the Supreme Court has crystallized the prayers, Mr. Mahanti? Nothing.
There is large number of prayers.
That is all while stating the facts, not that it will be limited to this. But stating the facts, they decided not to repeat everything. The various other prayers were also something made which need not be referred to for deciding these appeals.
Oh, for these appeals.
That rest.
All right.
But I will admitted to that rearrange the interpretation because annexure two will be one will be two and two will be one.
Page, annexure 1 will be page 20 and annexure 2 will be
21. That
annexure 1 will be page 20. Annexure 2 is 21 to 25.
The index has to change also.
Index.
All right, forget those. Yes, what is the dispute about?
The petitioner applied for loan for working capital and plant and machinery in the year 2004. Then a rate of interest was there because the act was not there. The act is the Micro, Small and Medium Enterprise Development Act came in the year 2006. That Reserve Bank made a different rate of interest applicable so far as these industries are concerned. Lord, then in 2006, I made itself a representation that I am in medium industries coming under the definition of the Industries Act. You please convert this rate of interest. Then they did nothing. Then I went on representing in 2006, 2008, everything. Then they granted me that benefit from 2010. But the issue is, my grievance is that if they charge the rate of medium scale industries on the loan of working capital and the plant and machinery, the interest that I have paid a lot of money in excess of the chargeable amount. And
After coming into force of this act?
yes.
After coming into force of this act,
No.
you paid more amount.
Because they will not renew it unless I have no other alternative. But I have been making them representation that you consider me. They considered me and granted me with the effect from 2010. So 2006 to 2010, I am not claiming from 2004. 2004 to 6, the act didn't come, so whatever I have paid, I am claiming from 2006 to 2002, that in and 9.
By way of right.
2009.
By way of right. You had a right to this thing, paying.
That is applicable to all medium.
All medium.
Why did you allow that?
No?
You are for the bank.
I'm appearing for the bank.
Right.
And the act doesn't prescribe the rate of interest.
Then?
They have banks.
Bank
they admit a lot of in their counter. They only say that since you have applied and entered into a contract, you are stopped from sitting it. If I am stopped, then how from 2009 you have given?
No, that benefit they have extended. It doesn't mean that you are. Therefore, we put this question: are you claiming it as a matter of right?
Because it is this act came into force in order to protect and develop these industries.
Where is the provision under the act that you shall be entitled to, you will be required to pay this much of
Reserve
interest?
Bank guidelines are there.
Where is that?
That is not annexed, but
Reserve Bank of guidelines were issued when?
right from 2005, 2006 onwards.
What is there?
There is a different rate of interest applicable. That will be benchmark
Micro, small, medium.
EMPL guidelines.
My lord, kindly come to Kindly come to page.
Where is that guideline? Say it as 2005, not 4 na 5 Union Bank would enter the guideline.
See, you will have to establish your case.
Yes, yes. No.
Your right.
Yes.
So had they not allowed you a lower rate of interest from 2010, you would not have claimed it.
No, after 10 there is no problem. I have got a problem from
No, that was on my representation.
That there was nothing, then why did they allow me for 2010? So did they commit this mistake by granting you this
No,
relaxation?
that was on my representation. They considered it 2006 onwards. They only considered it in 2009-10.
So what right did you have?
Well, I have a right of parity so far as other medium scale industries are concerned. If the Reserve Bank has prescribed a guideline for the rate of interest.
So that Reserve Bank of India guideline is not there.
No?
It is not there. You are not showing that.
No, that has not been filed, but
Has that been referred to?
that is there. Madam. Your Lordship may kindly see that 2009 renewal, madam, page 31, madam. I proceed. Go to page 31.
Circular.
Page 31.
Ministry of Small Business.
Page 31 of the writ application.
31 is Andhra Pradesh.
Yes, no, sir. I was
Andhra Bank.
I was previously in loaning of the Andhra Bank. Now it is
Union
Bank. After the merger. Lord, your Lordship will see sanction of the following facilities. Interest Public Commission, that last column, serial number 1, BMPLR at 12% as applicable to B plus rated as MSME account. So MSME account is charged BMPL.
So this was in 2009. How
Yes.
do you claim that this should have been for the previous period also?
That was the rate. If this is one, Lord, I couldn't make head and tail out of it. That is why I didn't give it to your Lordship. That is, this is the circular of the 2006.
For small industry.
What is Annexure 6?
Huh?
Annexure 6. Does it help you in any way?
Annexure 6 will help. As per extent RBI guidelines, an enterprise engaged in the manufacture, production or preservation of goods and whose investment in plant and machinery is more than ₹5 crore but doesn't exceed 10 crore shall be classified as medium enterprise. Please furnish full details of plant machinery with original cost as per latest audited provision.
But the interest rate is not there. That must be another document
So what was the amount, loan amount?
as per Annexure 7. 7 is your loan.
My loan amount is
My loan amount is 100 per CC and 900 lakhs per
cash credit.
cash credit is 10%.
How much?
10 crores.
Above 5 crores?
And within 10 crores it comes on medium. As per the act.
Yes, what is your stand?
Lordship, though we do not have proper documents, earlier the engaging advocate is ill now. We are engaged into this matter. We do not have all the relevant documents regarding this.
So we are directing the chief of the Union Bank
We are only
to
for
file
the
an affidavit.
opposite party number 4.
See. 2006. Whatever. This is Union Bank of India.
After the merger, Andhra Bank has become Union Bank.
Yes, unfortunately, notice has been issued to them
Yes, ma'am.
1 month back.
One, as per the cause list, my lord.
No, that is one thing. Whether any affidavit has been filed in this case.
Have you filed any affidavit? Counter affidavit?
I think so. The earlier engaging counsel has done what he has done. We need to ask them regarding to this.
She says that they are appearing, she says probably that she is appearing for the Union Bank. Previously, Andhra Bank was
another
appearing
counsel.
by another set of counsel. Now they
Legally
don't
counter
have
affidavit
records.
achi. Those old records have to be handed
Yes.
over to them. Counter affidavit filed by OPID. Counter affidavit has been filed.
No, but you are relying on this 16/1/2006.
Yes.
That was of the Union Bank of India.
I have given the Reserve Bank guidelines, they treated it for all nationalized bank. Andhra Bank was nationalized bank.
But Union Bank took it over when? I mean, sorry.
2013.
3 years, I think.
13.
Mr.
13,
Please,
I guess.
the document on which you are relying, this has been issued by the Union Bank of India.
Yesterday asked my one friend that you go to any bank and find out a guideline, otherwise what do I submit?
Because this will not apply for
They have also the same setup.
maybe, but they say in view of growing competition among peer banks, to compete with peer banks and to bring more number of SSI. This is policy of the Union Bank of India.
These are all nationalized banks. They will be bound by the
All other banks are separate entities. They must have taken decisions separately based on RBI guidelines or whatever, as requested on behalf of the Union Bank. You are representing Union Bank. Union Bank of India. List this matter on 2 weeks.
Yes, ma'am.
2 weeks, so as to enable her to. What will you do?
We are going to collect all the documents from the previous council.
If you serve the purpose,
Who's the
we can
previous
serve
counsel?
another copy.
I do not have any clue. My senior is going to come.
Who's your senior?
Bhaskar Panda.
To seek instructions, seek further instructions. This matter on 2 weeks.
There's a counter affidavit on record also. If you don't get from the other council also, you can get from the court. All right?
No problem. I can serve her also. In the meantime, I
who is
am
your-
permitted to that rearrange that annexes.
It will be. No, we'll ignore that.
We'll manage.
That.
The others page and again. purpose one.
Yes.
My lord, in this case, by
As per the last order of my lord, direct him to file a affidavit about the compliance payment of the subsistence allowance. I have filed the affidavit on record
Well,
also.
affidavit only yesterday served with
Yes,
the
I have
copy.
given her
What
copy.
is there?
What is that, my lord? They have not giving me 5 years subsistence allowance. Say, taking the plea that you are at that point of time you are getting honorarium. When I am dismissed, I was elected for Jilla Parishad member, and during that period, I was Jilla Parishad member and getting honorarium of 650 per month. That is the sitting
What is that document?
fee for the meeting, and that cannot be termed as a gainful employment. My
No
lord,
question of gainful employment. The question is whether you, as during the period when you were under suspension, You were an employee of which which is this?
KV, my lord.
Huh?
Kendriya Vidyalaya
Kendriya
Sangathan.
Vidyalaya.
Kendriya Vidyalaya Sangathan.
Vidyalaya Sangathan or not? Whether you were employee or not. Whether you were employee or not, when you were elected as Gram Panchayat.
No,
or
I'm
whatever.
dismissed from service.
So when
I am dismissed at that point of time, I am under dismissal. I am dismissed from service, and my lord, a judgment of Honorable Apex Court I have come across, my lord, that is stated even if he is a Jilla Parishad member and from Bihar, my lord, state of Bihar, he was an additional government advocate. And that can also be not treated that he has a government or he is doing any conflict of interest. He can be a Jilla Parishad member and getting honorarium and additional government advocate.
is additional government advocate a regular employment?
That's why I'm saying, well, I'm dismissal. In this case, I am under dismissal when I was Jilla Parishad member.
Alright.
So that is not any honorarium.
All right, you were dismissed. Now, how are you claiming subsistence allowance?
Because, my lord, in 2010, because of their mistake, because of the illegality, I have been reinstated.
You
So
have
that
been
is deemed
reinstated.
suspension period.
Deemed suspension.
Deemed suspension.
Now, if that period is considered to be deemed suspension,
My lord.
then whether during that period you could have been elected as Gram Panchayat or whatever or not.
My lord, Panchayat Samiti.
Huh?
That
Is
issue.
the only very short point I will address your lordship.
But
Whether that
that issue,
honorarium
Lord.
will be treated as a wages.
That is not the question.
No, you didn't. You missed the question.
That is not
Had
the
you been
question.
an employee, could you
I'm
have?
not an employee. There is no.
Listen. Had you been an employee, could you have been elected as Jilla Parishad member?
No.
No.
Yes, because you were dismissed. You were.
Yes.
So since you were not, and you have enjoyed that whatever Jilla Parishad member, whether you can
Subsistence
claim
allowance.
for subsistence allowance.
Then my case would be allowed, my lord, because I am a dismissed employee by that time. By that point of time, I am a dismissed employee.
So,
and I am just, I have no employer-employee relationship with the KV. Only due to the order of this honorable court.
So
I am-
therefore, madam, for the period during which you served the panchayat, you cannot claim subsistence allowance from Kendriya Vidyalaya. That period will have to be excluded.
My lord,
There is no question of gainful employment or whatever.
because my lord, exactly the law language is in 54 FR 53, my lord.
Yes.
That somebody, the subsistence allowance shall not be denied on any ground unless the government service is unable to, does not furnish a certificate that he is not engaged in any other employment. But this is not employment, Jilla Parishad, business.
Please let us read that provision.
My lord, FR 50. FR 53 is clause 3, my lord, subclause. The subsistence allowance shall not be denied.
Just a minute. Yes.
My lord, the subsistence allowance shall not be denied on any ground.
We are reading which 53?
My lord, FRSR 53.
53 what?
53 clause 3, my lord, subsistence allowance. Chapter 8, dismissal, removal and suspension. FRSR, fundamental rules and supplement.
Have you page marked that?
My lord,
The page mark.
Yes.
My lord, the subsistence allowance shall not be denied on any ground unless a government servant is unable to or does not furnish a certificate that he is not engaged in any other employment, business, profession or vocation.
Just a minute.
My lord,
53 को clause. 53.
FRSR, no?
This decision.
So where is that gainful word?
My lord, that's they are saying, their counter, they are saying you are gainfully
Forget
employed.
gainful. Forget that their counter affidavit.
Yes.
Let us come to this provision.
This provision only.
And this is very clear.
My lord, I am
This
not
is-
in.
there is no question of gainful. If you are engaged in any employment or business or profession or vocation during the period of suspension.
My lord, this Jilla Parishad is not an employment because I am getting only honorarium and that is to,
That is not here in the
that is
record.
in an election
That is
after
not on record.
only
What is
5
this?
years, my lord.
Vocation. It's a vocation.
This is not a vocation because You have to be,
Vocation means even if you are in politics during the period of dismissal, if you decide to join politics and later the order of dismissal is set
this is
aside,
service, my
you
lord.
may be
Politics.
denied. No question of service.
My lord, politics is today also regarded as a service.
That is a
Public
bhashan.
service.
That
My
is
lord,
not
only
the law.
on that point I will draw your attention
No
on next
question
week.
of drawing attention.
My lord, next week I will cite two decision. Your lordship may pass it. I will cite two.
Necessarily these
What,
are
you
rules.
brought some decision from Bihar, let us see. That is
My lord, that
additional
is
government act.
2018 Supreme Court. 2018 A,
These matters are
2018
unnecessary.
Supreme Court 3320. But that is very clear on this point that being a Jila Parishad member, that no way it can be termed as an
You
employment.
don't have an extra copy?
Madam,
Oh.
whether that judgment deals with the provisions under
Yes.
fundamental
No.
FRSR.
No, that is regarding disqualification.
Disqualification is something else.
Something
we
else.
are reading. We are dealing with these rules.
But this, I will just cite to convince your lordship, this is not a vocation, this is not a profession, and this is also not a business. Being in public service like politics for 5 years, being elected, that is not coming under these four things.
We are putting the same question. Had you been in service, whether you could have done that or
No,
not?
my lord,
That is the test.
Yes, I am dismissed. So I am free. I am free. I have no employer-employee
So remain
relationship.
free. Why you attached by that suspension thing? Why should you be attached?
Because my lord,
If you are free, then you
Yes.
should remain free.
my lord, getting a subsistence allowance is my right. So when I was not getting anything, as on date after 18 years, I am not getting my subsistence allowance. That's why I have elected and I got selected. Your lordship, I will convince your lordship on next
This is
Thursday.
2013 matter.
Yes, my lord, I will convince your lordship on next. Just
No,
one.
no,
My lord, yesterday they have served the copy. I am not prepared today. Only on this
Counsel
point.
appearing on behalf of the petitioner states that a copy of the additional affidavit has been served upon her only yesterday, which she wants to consider. First off, place this case on next Thursday. First off, we make it clear that we shall grant no further adjournment, considering the fact that this matter is pending for more than a decade. Yes. Yes. Not because you are going to satisfy us on that point, only because you have got the additional affidavit yesterday. Yes. Therefore, you have a right to at least go through that.
On 19 can take 1 week after. I am for the respondent.
Sorry, sir.
I am for the respondent. And on the question of contrast of delay, I was noticed and I appeared, and he has served me a copy of the appeal memo, and he is with regard to admission of the appeal. He is the appeal. I am for the respondent. And 1 week, on next week.
Yes.
My lord, I am undone because my law friend is submitting. Some time may be given, but a very short date may be fixed because we have been selected candidates with much pain and anguish. We are suffering for decades.
You are representing whom?
I am for the only the sole respondent.
OP number 5 and 6. There is the Tata Power.
On behalf of opposite parties number 5 and 6.
Very short date.
Next week. Why are you commanding us short date? We'll give. He is not seeking a long adjournment. Yes, Mr.
My lord.
Next week.
1 week after.
My lord, fix a date.
Yes, 1 week we have stated. You want 1 week after? You have stated 1 week.
Item 20, my lord. On the last occasion, my lord has directed to tag up the matters like WA number 2393 and WA number 2403 or 23, my lord. My lord, that has been tagged, my lord. And similar cases has been, my lord, delay has been condoned. My lord, in these cases also, my lord, may direct for condonation.
Payment of 20,000.
Yes, my lord. That one.
So you are earning a lot every day. How many cases are there today?
No, my lord, today only 2 cases and the petitioners are 4 more
Which item is
petitions.
this?
My lord, item 20, my lord.
20.
20. There are more matters than one.
5 matters.
Already earned.
Total, my lord, 6 matters are there.
Yes.
Among them, my lord, 4 matters already, my lord, my lord has directed to pay 20,000. We have paid, my lord.
In which item delay has not been controlled?
My lord, item number WA number 2393 in serial item number 3, my lord.
Serial 3.
Item 3, my lord.
393.
So delay has to be controlled in this
Yes,
case.
yes, my lord. 242 days, my lord. Similar, my lord.
240 days.
Also
242 days.
2403.
All like 20,000.
2403.
IA number 2403.
No, sorry. One. IA number
2393.
IA number 655. 2393. IA number 6555.
6555, my lord.
2393.
Yes, sir.
6555. Delay controlled.
Exemption.
And another, my lord, WA number 2403, my lord.
2403.
In that case, IA numbers 6653.
6653.
How many? More than one respondent or?
My lord.
Please tell us, but then it will have to be distributed.
I guess it has to be distributed.
My lord,
One respondent.
one respondent, my lord.
In Jasodhanai.
Jasodhanai.
In Jasodhanai, only one respondent.
2403, only one respondent, my lord. And another, my lord, so the previous one, my lord, 2393, there is.
All right, more than one.
My lord.
Yes, ma'am.
How many?
My lord. My lord, 1, 2, 3. My lord, total 6.
Yes. Whatever. Better. Yes, we can do it. Okay. 24,000.
24,000.
Will pay, my obliged.
Obliged. Why?
Last occasion, your lordship.
Just a minute. Why will you not address us on merits? Come for admission.
No condemnation of delay there.
Delay, condoning the delay, my lord.
Admission of delay. Not for orders. It says come for admission. Let's this matter on.
You
2
received
weeks.
the appeal memo?
Yes, my lord.
Have you received the appeal
Yes,
memo
my
on
lord.
these two cases?
Yes, my
All
lord.
right.
So we can hear these matters after 2 weeks.
After 2 weeks, yes, my lord. Yes, ma'am.
List these matters on 2 weeks. Any other matter?
No, my lord.
My lord, these are the
these 6
matters.
matters.
I plead with that. The last
Twenty
occasion, your
one, my
lordship
lord.
has directed
I
to
have
obtain
received the
instruction.
retrieve.
One.
Last occasion, your lordship has directed to obtain instruction to my honor
I have written-
with regards to my promotion. With regards to promotion,
Written instruction, I have received 10 days time to file response.
What is the instruction?
That they have to apply afresh when the notice advertisement being issued by the institution for promotion. Here they have wrongly perhaps filed the modification. I could not follow that. It I have for
my lord,
modification.
I have applied and faced the interview and my promotion is in the seal cover. Only they have to declare that. During pending of this repetition, which is no way affect my promotion. That's my prayer only, man. So during
So why was it in seal cover?
seal cover, because I have filed this repetition to redesignating me to the post of scientific assistant. That's why they have already withheld my promotion. And that is no way dealt with my
So
promotion.
you have been punished because of filing of the writ petition.
Sir, that is their view.
No, they are challenging redesignation some operation to technical person. So claiming one post, but now presently they are saying that we promoted. So I have written instructions received 1 week time to file response to that. So modification wrongly therefore that was a confused to me. That's why I
No modification.
What modification?
IA for application for modification.
Wrongly that has.
That's why confused me. That
No. Last occasion, your lordship.
Yes, you have written modification of order, is right?
Yes, wrongly,
That
madam,
confuse me for which
wrongly,
letter or
my
not.
lord, that has been written.
I have posted on behalf of the
2 and 3, F3 and 4.
on behalf of opposite parties number 2 and 3, list this matter on 2 weeks. Yes.
Obliged.
On behalf of Bimbisar Das, I am for the respondent number 1.
What is your name?
Allah Das, A Das.
May I please, your lordship. Your my lord, I am challenging the order under Annex 10. It has page 115, madam. Here, my lord, the present petitioners may take the leave. Before that, I can.
You are petitioner or appellant?
No, I'm the appellant.
Then?
The backdrop of the case, earlier occasion, one writ appeal was preferred challenging the order of the Honorable Single Judge, wherein 20,000 trained graduate schematic applications were there, and subsequently on the ground of preference and merit that has been decided. And this Honorable Court has been decided in the writ appeal number 580 of 2024 in 18/6/2024, my lord. That merit followed this preference, not preference followed the merit. Accordingly, Annexure 2 can have a glance, my lord. It is at page 445, my lord.
So now there is no purpose. The order has been passed.
Order has been passed. The backdrop, why I am saying, my lord, why I am saying, my humble submission of it. When this Honorable Court has passed the order in the writ appeal, thereafter government has passed this order under Annexure 2, page 45. For a moment, my lord. This is the office order dated 10/7/2024.
Yes.
There in the draft result sheet in respect of the junior teacher schematic published in the OSEPA web number 15/1/2024 was in alphabetical order of the names of the candidate for the document verification purpose. Subsequently, the district-wise, category-wise merit list of candidates was submitted before the
Mr.
High Court.
Counsel, this office order has been issued in terms of the order passed by division bench.
Exactly.
So what more do you want?
Subsequently, when this order has been passed, the district allocation and the merit of merit cum preference, the list was prepared. While the list was prepared, in fact, so far the reservation principle is concerned, so far the vertical reservation and the horizontal reservation, that has not been taken into consideration in its true letter and spirit. When the selection was not in proper process, so far the reservation is concerned, that being agreed by the same, I have preferred the writ application because it is a separate cause of action. That writ application was taken care of. So far this order is concerned, one more type of
notice. Issue notice. Process. You say notice. You accept notice?
Yes. They have state.
Yes.
May I pray this petitioners are
How this order can be passed, Mr.
without even considering, can have a glance to that page.
Have you seen? Serve a
But
copy.
this is a dispose of writ appeal. Can I
copy?
See, the list of
Others it won't be numbered.
number.
So when did you serve? You tell them, they will try to retrieve.
I can serve another copy.
Only.
That will be better.
Yes. I can serve another copy. No, sir.
2 weeks.
But without hearing, can I be a party in the writ appeal which has been disposed of
No, you have challenged that order.
Exactly.
So you serve a notice, serve a copy on him, we will consider this order, correctness of this order.
May I play sorted, can it be? Because they are going to fill up because
No, let us see.
20,000 posts are there.
All
They are
right.
going-
All right. 2 weeks.
2 weeks only.
Oh, deep blue.
It's a small matter.
Man.
May I plead your lordship? The petitioner is a student, your lordship, who is appearing for all the examinations, your lordship. Petitioner is a student and appearing all the entrance examination to get into the courses, your lordship. In the present case, your lordship, he has filed application to get into BSc nursing home, your lordship. And the petitioner is suffering from sickle cell disease, your lordship. Annexure 1, page 13, your lordship. That is a certificate issued by the competent authority, that the disabled certificates in favor of the petitioner. He is having 60% disability and issued with the certificate, your lordship. And annexure, your lordship may peruse annexure 3, that is the advertisement floated by the director of DMET, Odisha, for various courses, your lordship. Pursuant to the direction, the petitioner applied for the course BSc nursing.
Have you served a copy on Mr. Mahanti? No, he is not appearing. Anyway, carry on.
Here, your lordship, annexure 4 series starts from page 18. Personal information, your lordship. Annexure 4 series starts from page 18, your lordship.
Yes.
Personal information. Is physically handicapped? He filled up yes, your lordship. These all applications have been filled up online, your lordship. Now your lordship may peruse annexure 5, that is the brochure of the course, your lordship. This brochure they are maintaining, they are following since 2021, your lordship. Annexure 5 starts from page 21, your lordship.
Yes.
And page 22, the same brochure they are using it for 24-25. First line, your lordship. Application for and prospectus for admission into different nursing courses for the academic session 24-25. And this same guideline they are following in 24-29, your lordship. In this guideline, your lordship may peruse.
Sickle cell is not included.
Yes, your lordship. Page 27 of the brochure, your lordship. Running page 27. That is reservation, your lordship. There in serial 3, 5% for persons with disability in each category of UR, ST and SC. And below that, your lordship, in note 3, they have specified the seats reserved for PWD category, person with disability PWD, will be filled up by the persons with benchmark disabilities in accordance with the provisions of the Rights of Person with Disability Act 2016. Now, your lordship, page 30, your lordship. Page 30, 13. Page 30, sir.
Oh, yes.
Item 13, your lordship. Serial 13, 1-3. There they clarified, persons with disability certificate issued by the SSEPD department, Government of Odisha, is accepted through online. Certificate issued by any other mode will not be accepted. The percentage of disability, locomotor disability of lower limbs between 40 to 50% only will be taken into consideration. That is medical board qualification. And 14, the candidates having any other disability will not be eligible to participate in the counseling. So my respectable submission before your lordship, where at page 27, they have
Just 14. What is 14?
14, candidates having any other disability will not be eligible to
Will only be eligible.
Candidates having any other eligibility will only be eligible to participate in the counseling process after production of genuine medical board certificate and will be treated under the unreserved category. Now, your lordship, with Disability Act 2016, Your Lordship.
So they asked you sickle cell is not included.
So did you challenge this advertisement on that ground?
Your Lordship, I have applied in 2022 also, Your Lordship. I have demonstrated all my documents, Your Lordship, before Your Lordship.
No, but since it was clearly mentioned in the advertisement that no other disability can be taken into account, then did you challenge? You participated in the process of selection.
Lordship, I will demonstrate for the different course, the self-same authority in 24-25 has issued another advertisement had Annexure 8 where the
Right.
You're asked.
We are concerned with the present selection process. Let us see which provision you are
Yes,
referring to.
yes, Your Lordship. Section 2R, Your Lordship.
Category or something.
Which provision?
Section 2R.
Categories.
Pardon?
Categories of
Yes.
disability.
A person with benchmark disability.
Rights of persons with disabilities. Are referred.
Yes, 2R then.
Person with benchmark disability means a person with not less than 40% of a specified disability, where specified disability has not been defined in the measurable terms, and included a person with disability where specified disability has been defined in measurable terms as carried by the certifying officer, Your Lordship. And the specified disability in ZC that has been defined, Your Lordship. ZC. Specific disability.
So let us come to the schedule. Why are you referring?
Yes, Your
to
Lordship.
provisions?
That schedule has been included. That's what I am trying to bring your Lordship attention. That is the schedule. Specified disability.
Yes.
There the specified disability, Your Lordship, in the fourth, disability caused due to A, B, C, and B is the blood disorder, Your Lordship.
You mean to say that you are
I am included
your,
the sickle cell is
disability
included.
is included, but that has not incorrectly or illegally not included in the list of reserved.
Obliged, Your Lordship. Obliged.
So you could have challenged the advertisement.
Because Your Lordship,
And you're saying since 22 you have been deprived.
though I have written to authority in 2022, Your Lordship may peruse Annexure 8, Your Lordship. Annexure 8 starts from page 69.
Same day we can put it. That ex-serviceman thing.
That is, I think that is in page 46, perhaps, Lordship, page 46, I think. The schedule.
Yes.
Schedule. The disability, page, next page 47, the disability caused due to, and page 40 is the relevant part, Your Lordship. B, disability caused due to blood disorder. And Romanic 3, sickle cell disease means a hemolytic disorder characterized by chronic anemia, painful events, and various complications due to associated tissue and organ damage. Hemolyte refers to a destruction of cell membrane of red blood cell resulting in the release of.
So you have a certificate
So
for sickle cell.
that sickle cell is included in schedule, Your Lordship. And Your Lordship must.
Mr. Counsel, even if your submission is correct, it is difficult for us to entertain, also for the reason that there is exemption provision also under the Act.
Yes, Your Lordship.
So, keeping in mind nature of service,
Yes, Your Lordship.
some of the disabilities can be excluded. The provisions can be excluded for some of the services in respect of some of the disabilities, like say in judicial service, a person suffering from visual and at the same time audio, this thing that can be excluded. So it depends, and we don't know what happened in the background.
The Lordship may peruse Annexure 8, Your Lordship.
What
The
Annexure 8?
self-same authority they issued another for master, another advertisement, your lordship, for
For what?
different courses.
For what?
Paramedical and allied
Paramedical.
medical science.
So therefore, there is difference.
This is nursing, that is paramedical, your lordship.
Maybe.
And they have not assigned any reason to
Where is
why
the question
this-
of reason? In the advertisement, they will assign reason.
And
They could
lordship-
have assigned reason in
and
their
th-
counter
this-
affidavit.
That,
had
your
you
lordship,
challenged.
for lordship query that I have mentioned in,
Because just look at it this way, nursing, you need a little more ability for radiology, public.
And that too, just
physiotherapy.
see the effect of this, the disability which you have. See
That is
the
a
effect
sickle
of
cell.
disability as described in the act itself, in the schedule.
Nursing, you have to be able-bodied. You might have to lift the patient also.
this sickle cell, your lordship, it doesn't have any effect with the nursing, your lordship.
Doesn't make you weak.
Nursing.
Doesn't make you weak.
But sickle cell, it doesn't have any, that I have mentioned in para 11, internal page 9, your lordship. And the other advertisement issued by the same authority, that is DMET, your lordship. There they have included,
Nursing is a different.
though they have included the PWD Act and they have included the Schedule 2,
Sickle
your
cell
lordship.
means a hemolytic disorder characterized by chronic anemia, painful events, various complications due to associated tissue and organ damage. Hemolytic refers to destruction of cell membrane of red blood cells resulting in release of hemoglobin. So where is that example?
Your lordship, page 78, your lordship. The other advertisement issued
Sorry.
by the same authority.
Mr. Counsel, if there is any other advertisement in relation to the same post, then your case can be considered. Same thing, same seat. And then when was the advertisement issued?
In some June, your lordship.
Huh?
So this year, admission.
25, 2024,
admission
your
for this year.
May 20th.
May?
May 20th.
May 2020.
No, 2024. This
May
last-
2024.
Yes, your lordship.
And the selection is process is complete.
Just examination is over and provisional merit list has been published, your lordship.
What is
Where
that?
I have been selected, but I was not taken into that PWD category, your lordship.
Because of that clause.
Because of that,
the advertisement, they cannot deviate from the advertisement. They have rightly done it. They cannot deviate from the advertisement, and for you, the advertisement cannot be changed.
And you should have challenged it before, because that is totally against you.
Or you could have stated at the time of applying.
at the time of applying, I have mentioned everything, your lordship.
Even without that, we cannot ask them to deviate from the terms of advertisement. So unless we either we quash the advertisement or we follow.
Schedule 2, in the last paragraph, your lordship, any other category may be added by the government, your lordship. They cannot deviate from Schedule 2, your lordship. And in the advertisement, very well, your lordship.
Mr. Counsel, whether persons in the army can be recruited with these disabilities, because there is exemption. The organization or a department.
There is no such.
The
Any alternative remedy there?
Section 20,
20.
Your Lordship, Section 20, Your Lordship, may kindly see. Non-discrimination in employment. I'm reading the proviso,
This is not-
provided that the appropriate government may having regard to the type of work carried on
Exactly, this is the exemption thing.
in any establishment by notification and subject to such condition, if any, exempt any establishment from provisions of this section, my lord. They can exempt. That's,
This is employee. Here he wants to study the course.
yes.
नहीं who is the
Notice DMET, the specific prayer has been made against the DMET. So Mr. Mahanti, Rajani Mahanti, he is appearing.
Have you served a
usually.
copy on him?
No. I've only served a copy to government.
They have to serve the
He
copy
has
to
to
Adanimanti as well as to us
also,
because the
complete
Indian Nursing Council is a made up party.
SSPD department.
Correct, correct.
Which is the nodal department, so far as persons with disability is concerned.
what is that SS?
SSPED.
SSPD department. That,
But counsel for the petitioner is permitted to implead SSPED department for as opposite party to its secretary.
Hello, secretary.
As opposite party.
It is social security and empowerment of persons with disabilities department.
Social security.
Social security and empowerment of persons with disabilities department, Odisha.
Issue notice. Mr. Das, this is notice on behalf of the added opposite party.
One and the newly added, I'll take.
One and newly
DMET, my
opposite party. So submit a copy of the petition is served on counsel who represents DMET. So submit this matter on 2 weeks.
On behalf of Mr. Kanungu, I pray for next week.
Why has it been listed?
Mention.
But yesterday was it must have been listed on mention, or it's a new matter.
Day before yesterday it was there.
But Mr. Kanungu was there before recess?
He was there when he had a flight, so he had to leave.
No, it's not important.
This is matter on Monday.
Monday,
Tuesday. Posted on behalf of the petitioner.
26, my lord, this medical tender, my lords, for supply of orthopedic implant, my lords. Your lordship were directed, I had filed the additional affidavit. On the last occasion on 29th, I filed the additional affidavit, and on the same day, the tender has been cancelled, my lords. They have cancelled the tender on 29th, and on 2nd, they have floated a new tender, my lords. So I'll have to withdraw and file a fresh application.
In view of the cancellation of tender notice in question, this writ application has become infructuous and disposed of accordingly. And is disposed of accordingly.
Item number 27.
Yes, my lordship, in item number 27, valuable government land is encroached by some encroachers.
File your, go before the magistrate.
My lord,
But
Go
that
before the
Trinath
magistrate.
Panda judgment, even though my friend has not complied to Rule 88, the High Court rules, Trinath Panda can not come to his rescue.
Trinath Panda.
no, already I have complied the High Court PI regulation.
Go before the
Trinath Panda
magistrate.
judgment अनुसारे आपण file करिवे High Court judgment before the magistrate. If he doesn't comply, then it shall amount to contempt of court.
Yo.
My lord, in that objection, my lord can send
Yes, yes.
to Tahsildar.
We will send.
No, my lord.
My lord will send.
Can direct the Tahsildar to hearing all the party, including encroachers.
We are giving you liberty to approach competent authority. That will be the order.
No,
In
I
the light
have,
of this court's decision.
my lord, I have already approached collector and Tahsildar.
So
My
you
lord
want
may
us to
direct
pass on.
Tahsildar to hearing all the encroacher and take a suitable decision.
That is the order.
My lord.
Item 28.
May I please your lordship, my lord? My lord, this matter relating to ITI colleges, my lord. Last week, my lord has heard these matters, and some of the matters are left or had not been listed due to defects. The similar matter, my lord. They have not complied the deficiency. What the deficiency? They have not stated as the deficiencies, and they have disallowed the colleges.
Have you served copies on Mr. Mahanti?
No. It's my lord, ITI colleges.
Sorry,
my
I'm
lord.
sorry.
ITA.
The
That
government.
ITA
Government.
other best matters are also fixed to 11th, I think.
11th, my lord.
List is matters on 11.
My lord, there should be interim order because on virtue of your interim order, all the colleges are admitting the students. These 4 colleges are, my lord, suffering because there is no open. There is the portal is not open to them.
Interim order.
Had you applied when the deficiencies were
My lord,
pointed out to you? Have you applied?
My lord, my
Is there any endorsement?
My lord,
What is the interim order? Do you have a copy?
my lord.
Your lordship, but your lordship, I may be pardoned too.
Yes.
Your lordship has specifically said that after 31st of August, there would be no admissions, your lordship.
In this case or the
In the previous cases, your lordship. The 12 matters that were there.
My lord, after 31st, they have extended the date, my lord.
Where is that order?
My lord, paragraph 8.
Where is the order?
Para 8, my lord.
Para 8 is submission.
That is why we disposed of the application. Was 2 days. 2 days were left for making.
And now
application.
the cutoff date has been extended, my lord.
You have some
Where is
document to show that.
Where is that? Para 8 and 10. 10 also lost to reiterated 31st August. That's why also directed to file the counter affidavit within 2 weeks. And matter was
My
directed.
lord, now the DTT has extended the date, my
So
lord.
where is that document? Tell us. Show us. Have you annexed with your writ petition?
No, my lord, on that day that writ petition was filed. But unfortunately, it has not come to the
Do
board.
you have it in your hand? We know you have filed. You are not understanding our
My lord, my lord.
question. That you are saying that the last date has been extended beyond 31/8/2024.
31st 9th.
Where is that document?
I'll produce the document, my lord. It is in the
Then if 31, then you can wait. For
my
the
lord,
other,
other colleges are taking the admission, but
so all the students will, I mean,
My lord,
Other
my lord.
colleges are taking it. It is not paragraph 8. It is paragraph 11.
11.
8 also it is there. Last date of admission. We submitted, thereafter we have directed.
Subject liberty to your training, which shall be subject to under obligation to inform the trainees who are given admission that such admissions are subject to final adjudication. Their admissions are not created any equity in this.
No. Last date has been 31st. We said this has been extended 31 days. That is why it is
my lord, the modified date is 39th, 2024.
Print out the medical vehicle. Mobile.
My lord, I have in the mobile, my lord, the printout I have not available.
What?
The extended date, my lord.
Extended? Have you extended the date?
But in fact,
You
neither-
show Mr. Samantare. No, but another thing.
No, and without going through the records, we cannot pass any.
My lord, already I have shown, my lord.
You have shown, we will keep it to a short date, because the other side needs to be there. Let it be 3 days, 4 days, but it has to be there.
My goodness.
All right. Let it come on 11th, because now the date has been extended.
Extend, my lord, the other colleges, the 10 colleges which was
because the
before your
shops are
lordship, my
open,
lord, they are
shops
taking
are-
all the candidates, my lord. My colleges,
Because according to you, because the shops are open and your shop is closed,
my lord, my lord. Because
we are not doing business here.
Do you think people will stop buying? They will continue to buy.
no, my lord, there was a defect in the.
So
11th.
categorically, we asked you on that date, are any applications pending? We told no, everything has been listed.
No.
Item 29.
And Mr. Goswami, your application has been filed on 31/8/2024. Yes. So why do you say defects were there? That order was passed on 28th.
No, on the same.
All right. Okay.
29.
Your Lordship, may I please the court? Your Lordship, the petitioner in the present writ application challenges the Annexure 6, which is an ad interim order of attachment under Section 3 of the Odisha Protection of Interest of Depositors Act, my lords. That is at page number 126 of my writ applications, my lord. So for the sake of convenience, I have got an extra copy of
You are challenging Annexure 6.
Indeed, my lords. The petitioner challenges Annexure 6, my lords, on the ground of being procedurally ultra-virus, my lord. The procedure which should have been adopted in attaching the properties of the petition has been provided under Section 10 of the Act. However, they have resorted to the power provided under Section 3.
OPID Act.
Lordship, I have an extra copy of the Act for your Lordship's convenience. Lordship, it's been flag marked. Your Lordship, may I place Section 3 for your Lordships?
Right.
Section 3.
Section 3. This order of attachment, which is under Annexure 6, my lords, is a Section 3 attachment, which my humble submission is that such an attachment is not permissible under the Act once the properties of the financial establishment have been sold, my lords.
Section 3 you are referring to?
Yes, my lords. Section 3 of the OPID Act, my lords. I have also reproduced the same at page number 15 of my writ application, my lords.
Please.
Attachment of properties on default of return of deposits, my lords.
Yes, please.
Yes. Notwithstanding anything contained in any law for the time being in force, whereupon complaint received from a number of depositors that any financial establishment defaults the return of deposits after maturity, or fails to pay interest on deposits, or fails to provide the service for which the deposit has been made, or where the government have reasons to believe that the financial establishment is acting in a calculated manner with an intention to defraud the depositors, the state government has satisfied that such financial establishment is not likely to return the deposits or to make payments of interest or to provide service. The government may, in order to protect the interest of depositors of such financial establishments, pass an ad interim order of attachment, attaching the money or other properties alleged to have been in the name of any other person from and out of the deposits collected of the financial establishments, if it transpires that such money or other property is not available for attachment or not sufficient for repayment of the deposits. Such other property of the said financial establishment or the promoter, director, partner or manager or member of such financial establishments or person who has borrowed money from such financial establishment to the extent of his default, my lords. So this particular provisions provides for attachment of financial properties belonging to the financial establishments, my lords.
Now, my lord, the present properties which have been purchased by the petitioners are from such one financial establishments, my lord. However, this purchase were not a candlestick purchase or a hidden purchase, my lords. We had presented certain sale deeds before the sub-register at High Court. Those sale deeds were not processed, my lords, for which we moved an application before a coordinate bench of this honorable court. And your lordship, that order is before your lords as annexure number 1, my lords, which is at page number 36, my lords. It starts from page number 35 of my writ application, and the operative part is at page number 36. So when we purchased, there was no such order of attachment, my lords, restricting the sale or purchase of such a property by the financial establishments. Now I'm placing the operative part of the order of the coordinate bench of this honorable court, which is at page number 36, my lords, and paragraph number 7. In view of the matter,
26.
Page 36 of the writ application.
36, yes.
36, and the operative part of the judgment is paragraph number 7, my lords. That in view of the matter, the letter under annexure 2 issued by the Superintendent of Police EOW CID CB Odisha Bhubaneswar is without jurisdiction and is hereby set aside. Consequently, the writ petition is allowed, and the sub-register High Court opposite party number 1 is directed to registration of sale deeds under annexure 6. These were my sale deeds, my lord. But this coordinate bench has allowed the registration of the same in my favor, my lords, because there was no attachment order. Now, your lordship, this order was also challenged before the Honorable Supreme Court by one of the interveners. The Supreme Court also upheld this particular order and said when there is no order of attachment under section 3, there cannot be any restrictions on sale and purchase of such properties. Subsequent to that, we paid registration duty, stamp duty, and got those properties transferred to my name, my lords. Subsequent to that, we have also got the RORs published in my name.
This order of the learned single judge is in a different background altogether.
My lords.
You had a grievance that the sub-registrar is not accepting your documents for registration because of some direction issued by a police officer. So in that background, the learned single judge has said that that point is no more res integra. The document presented has to be registered. That's all.
My lords.
There is no
My lords.
no adjudication on the point of transfer.
My lords. So those registrations were allowed. Subsequent to that, the mutations have also accrued in my favor. My lords.
Mutation, that is different.
My
It's
lords.
a question of attachment.
My lords. So the statute and the lawmakers in their good sense, your lordship, have come out with a separate provisions for attachment of such properties here, my lord. Now that is in section 10, my lords, of the Act.
And what about section 3?
Section 3 talks about ad interim attachment of properties which used to belong to the financial establishments, my lords. My submission, humble submission, your lordship, is that once the properties have been transferred to my name, recorded in my name, so the properties now belong to me. And in such a situation, my lord, the resort has to be made to section 10 of the OPID Act, my lords.
Just to avoid it, it was done, no?
My lords.
The properties were transferred.
My
Just to
lords.
avoid the rigor of section 3, the provisions of the OPID Act.
No, my lords, I am still subjected to the trial, my lords.
Yes.
But the trial should take place as per section 10, my lords.
Yes.
In section 10 also, I face the same consequence.
Yes.
If I am unable to prove that the transfer were not mala fide transfer,
Yes.
or on the other hand, the OPID establishes that this is an mala fide transfer, I will still lose my properties, my lords.
Yes, this is ad interim order.
My lords. Now, your lordship may be allowed to place section 10 for your lordship's kind consideration, my lords. Attachment of properties of mala fide transfers.
Why are you referring to section 10?
My lords. So
section
section 10
is final. You are challenging an order which is ad interim under section 3.
My lords.
So 10 decision, 10 stage is yet to come.
My lords, the only way once the transfer has been effected, my lords, the properties can be attached is by section 10 with the finding that these were mala fide transfers. The problem with an attachment under section 3 is, my lords, that first they will attach it without giving me an opportunity of hearing, my lords.
Absolutely right.
My lords, if your lordship will see the consequences under section
So have you challenged the virus of the Act?
My lords, I have challenged the virus of the executive action, my lords.
No. The Act is there. Act is very clear.
My lords, I'll just point out for your lordship's kind consideration, section 10, your lordship.
Section 10, why should we go to section 10 where no power under section 10 has been exercised? Section 10 stage has not reached. Then why should we read section 10? The power has been exercised under section 3 and you want us to read section 10?
Because, my lords, your lordship, I'll just address the concern in a moment, my lords. When we look at section 3, it talks about or provides for attachment of properties belonging to the financial establishments, my lords. What I submit.
All right, just a minute,
My
just a minute.
My lords.
Yes, it's clear. Financial pass and interim order attaching the money or other property alleged to have been procured either in the name of financial establishment or in the name of any other person from and out of the deposits collected by financial establishment. You have purchased the property from the financial establishment.
My lords, that I do not deny, my lords.
Sorry.
Lordship, I just be allowed to point out another decision of this Honorable Court's coordinate bench, where they say that in order to resort.
You are repeatedly saying this coordinate bench.
My
Please
lords.
try to understand the meaning of coordinate. Then you, unless you have the, you know the meaning of that expression, coordinate bench, you should not use that.
My lords, I seek apologies, my lords.
There is
stand
difference
corrected, my
between.
lords.
We are not satisfied. Sorry.
My lords, I may be permitted to withdraw, my lords, or seek an alternative.
Appearing on behalf of the petitioner after some argument seeks permission to withdraw this writ application. We make it clear that we have not gone into the merits of the case, merits of the case and the points raised in the present application. The application is accordingly dismissed.
Much obliged, Your Lordship. Yes, ma'am.
Item number 4.
30, my lord. I pardon my lord, I'm virtual mode. I have not 30, small matter. Tomorrow I have some difficulty. That's it. Let it take a
Item number
30. Next item.
No,
Only for limitation, non-limitation notice had been issued and they have appeared.
What is the delay?
30, I am appearing for the opposite party activation.
Just a minute. What is the delay?
Earlier the application was filed, and after the application was the player was defective, it was issued different, and that's why I filed another application. And this application
We will take up your matter on Tuesday.
Yes, madam. Tuesday. Not tomorrow.
Tomorrow, no. Tomorrow it will not come.
Yes.
Item number 4.
This is regarding the prison visits.
Yes.
This is regarding the prisons matter, manager.
Yes.
Here, on the last occasion, I had given a short note comprising of the relevant pages of the reports of the DLSs. Now, the first issue was regarding that open air jail, where the original report, my lords, is there at for July. The report is there at the part of the record, page 4. That note.
Which note?
short note for 13/8/2024. I'm told that it is on top of the record. And capital A is the report regarding Biju Patnaik open air ashram.
Yes, this is open, maybe ashram, but it is not open air. Like any other jail.
Here the report, the points of concern here would be at page 4 of that report. Conditions of jails and behavior of jail authorities.
Yes.
This is what the District Legal Services Secretary my lords writes. Behavior of jail authorities under serial number 2.
Yes, who is for the estate?
Yes, my lord.
Now, I just want to draw my lords one attention. This was in July. In August, there's a fresh report which has come at flag 182. And of your lordship's brief, it would be at page 8660. The same thing has been again repeated. So I just wanted to say it in the same breath that whatever was the allegation in July, in August also the same thing has been reiterated. My lords would see that at page 8660 of your lordship's brief.
Yes.
Same allegations have been repeated for the past 2 months. And in fact, the allegations are for, this is the third round of report regarding that particular jail.
And the
Same superintendent. August, it is still worse. August, which if your lordship sees page 8660,
We are asking them to respond, the estate.
Yes, sir.
If I can quickly point out regarding other jails also, the allegations regarding hygiene, regarding kitchen, same thing is being repeated. So if they can have an in-house mechanism that once these magistrates, they report something, they should quickly respond and rectify it so that it's on an auto mode. It doesn't have to come to your lordship's. These small things, one kitchen not functioning, food is bad. A mechanism has to be developed where it's rectified immediately. These are all, after all, judicial officers visiting, giving detailed reports. Somebody has to.
We also sometimes visit and give reports, but why do they have to wait for that?
My lords, once they say something, it can be.
All right, let them respond for the
Yes.
present.
Yes.
We will try to evolve a mechanism.
Yes, ma'am. Yes, I will. I know that. I will do.
Otherwise, I'll again
Yes, my lord. I will.
direct for developing a portal.
Yes, yes.
Everything. So everything.
Then every day you'll have
Put,
hundreds.
you put everything on portal.
No, my lord.
No requirement of seeking anyone's.
Definitely, my lord.
We can develop, Mr. Vishwa, it's a good idea that you developed points on which there should be information on the department's portal. All right, they'll be under obligation to put everything like hygiene, sanitation, this thing, the number of UTPs who have been allowed bail and have not been released. So it should be their duty to put everything public domain. And then instead of seeking any report from the legal service authority or something, everything shall be available.
That can be a good check.
And then we can have a grievance portal also or something.
And
Grievance.
find that they are not.
So there can be one slot for them for the grievances also.
Yes, yes.
Every day you'll have 1,000 grievances all over the state.
If you don't improve, then we have the system.
No, yes, my lord. We will improve, my lord.
As you wish.
We have filed one affidavit on 37/24, my lord, where we have.
From that affidavit only the note will be released.
Yes.
Yes. We have.
I have factored everything, including the
Yes,
new
ma'am.
reports. Now, what is worrying is that if the magistrate, these are all judicial officers doing this full time, so they must take heed. It also, I feel very bad to tell your lordships that one kitchen, the food is bad, one jail, there's no.
No,
The
therefore,
toilets are not
just,
clean.
just Mr. Mishra, that is the way you can see, if the member secretary DLSA, this is how we can control all the jails. Member secretary DLSA will have reports from our office there in the, all the jails.
They are doing it.
So he can seek reports and then he can present that on that portal. This information will also be available.
Yes, ma'am.
What steps have you taken to address those?
Address those issues.
So you just tell us the points which can be suggest us a format which they will accept, and
Yes, yes.
as has been done in case of these schools.
Yes, yes. I will do.
Easiest way.
If they are agreeable to it, then that's a
do it.
Yes, yes. Why? The convicts are the responsibility of the judiciary, mainly because of the order of the judiciary, they're been there. And yes, yes. That is true, my lord. And also because we are the ultimate.
This matter on 2 weeks. First off, in the meanwhile, let counter affidavit be filed by IG Prisons.
Yes, ma'am.
Affidavit be filed by the IG Prisons addressing the issues raised in the, where is that report?
Raised in the note dated 13/8/2020. I'd served it much earlier.
Yes, yes, it is there. That note is
There
there.
are issues highlighted in the short notes. Short notes, quote unquote, short note for 13/8/2024. Unquote.
There are only 4 issues. One is open air. Other one is 2 jails regarding.
Submitted by the learned Amicus Curie. Based on the, this is based on 12/7/2024.
This is based on 12/7, but I have also cross-checked it in the meanwhile.
But what we would suggest that instead of your submission, we can refer to this report of the Secretary DLSA.
This report is also given to them.
Yes, yes.
So that has been given to them.
Yes,
and
yes.
they can address those issues.
Yes,
which
yes.
have
They can.
Huh?
They can.
address the issues raised in the report of, this is only Jamuhari.
That Jamunjhari, that is the open air jail. Then page 10, Baliguda is also given
Same,
to them.
Same. So that includes everything. Your
Yes,
short
yes.
notes
Includes everything. It would be easier for them to deal with
All
this.
Deal it. This case on. Next, we request Mr. Gautam Mishral and Senior Counsel and the Amicus Curie to suggest the court the points for developing a portal to be managed by the prison department or
Directorate.
prison directorate which may be placed in the public domain, put in the public domain, subject to necessary restrictions for an effective monitoring of the condition of prisoners in various prisons in the state. Just tell us the points. You can prepare this thing.
I would
Excel
prepare.
sheet. 3 weeks.
3 weeks. There's one more small issue, if I can draw your lordship's attention. This bail bonds. They are doing a good job. The numbers, they are repeatedly giving a report, but there are 3, 4, 5, 6, which I would just draw your lordship's attention if your lordships have the time. Those some of them have already been, the good work has happened. But there are 3, 4 which I would like. There's a lunatic. He's still in custody. And then the Supreme Court order, that suo moto order, it says that they have to suo moto take it up and release. Or if they are not able to arrange, then they can release them for a few days, see if they can arrange and then come back. But that is not being done in our state. They are requesting the local advocate, the local. There's a specific provision in the CRPC. If he, there's a provision. So in any case, he can't be in custody. That's against all the norms of CRPC. And these people, my lords, if your lordships would see that CRPC provisions, my lords, would be there regarding lunatics. They start from 328 and go up to 339. And specifically, there is a provision at 330. So I'm not seeking for any reliefs, but these are the worrisome ones. If your lordships would see that note, like this entry at 142, he's there since 4/9/2023. So that Supreme Court order regarding release. So once somebody is released on bail, thereafter keeping them for years, one such case, my lords, which shocks me, would be 2016. Bail order is from 2016. One more at 27, serial number 278. Date of release order is 19/8/2019. But then there has to be something evolved either by the UTP. At least, my lords, in jail, that's not the best place to have. At serial number 278, the person was released on bail on 19/8/2019. Now, what the DLSs have found out is that the UTPs of unsound mind and none of his family members or relatives are visiting him in jail, Sambalpur.
I'll PIL on this. We will see.
I just wanted to draw your lordship.
Yes,
I'm not against anyone. I'm just saying that this is something which has come.
Let there be separate proceeding. Otherwise, we will be doing it so moto. But just we shall address this issue separately and pointedly.
In fact, in this PIL, separate interim judgments have come about regarding various issues.
It's becoming voluminous. Because
that's of course.
So we can see if instead of
so this is one such issue. Then there is another case of a Nigerian. Of course, these Nigerians, my lord knows, these are all hackers. They siphon away money. So the allegations may be tough, but he has refused legal aid. So then these are issues which somebody has to deal with. I just came to my notice, that's why I have brought it.
One by one we can.
I don't want to trouble your lordship with all these issues.
Otherwise it has become jumbled up. Everything.
But this is a part of the legal aid reports which have come from that only. I'm trying.
Better if we address separately. Otherwise, times because of the volume, in fact,
we would do.
The list is in, I think, 10 pages or so. The daily cost list.
That in fact, it's not required because the 2014 entries, those have all been resolved. I don't know why they are bringing it. The prisons manual came about because of this, but those can be by the registry. They can.
Please.
Because of your lordship's supervision, the jails are becoming very welcoming place, my lord, to stay.
So you want others also to go.
So it is a heaven for many people. Yes, it is, and safety. I know many criminals, they feel safe inside a jail. Yeah, I love.
So is the stand of Odisha that
no, my lord, in some
no
districts,
is a safety home.
in some districts of Odisha like Ganjam, there is honor killing. If you kill somebody and he is out, the other party kills him. So it is better for them. Sometimes I pray in the court that he is a protected custody. And sometimes
those were the days.
Protection. You are giving.
Those were the days, not nowadays.
No, but nowadays, my lords.
Very recent incident.
All right. Yes. Let's start now. TV. In the meanwhile, you also can ask your department.
Yes. I am addressing all his notes.
And not only this, what we have requested Mr. Mishra to do, your department can also do.
Yes.
So they can also suggest.
Yes.
So that maximum things, most of the things are placed in the public domain. Anyone can.
Yes.
Pardon, Miller.
Grateful to your lordships.
On original writ of appeal, Miller, execution proceeding attachment order is going to be passed recently, Miller. Yesterday I have mentioned that, Miller.
Yes, your slip was there. The date has been given. Some date has been given. Some date has been given that was placed before me.
Miller.
See.
On 10th.
See the efficiency of the Chief Justice.
Miller.
That you made a mention yesterday.
Miller.
And today you are being told by the Chief
But in your
Justice.
memo, you had not stated on which date the execution proceeding is posted. Anyway, you have got the best possibility.
Miller, last date was posted on 8/28. The honorable subject did not grant any time.
All right, we will see.
Attachment order was going.
Yes.
Matter limitation is there, appeal. When total has been seized, the limitation there. Opposite party of appeal to appeal.
I have
an objection also.
I have filed objection.
58 days limitation.
58 days condition.
I am for the opinion of
Lordship may see the objection also. Writ appeal has become infructuous.
No.
Because
all right, we
he
are
has waited
controlling the delay. We
deliberately
will
and
take up
after
the matter on Tuesday or Wednesday.
my lord, on Tuesday, Lordship.
Tuesday, delay control. 58 days.
35.
The
35.
limitation is simple, so 6/1/70 of 2024. I am
Number of days delay?
57, 58 days.
The item
I am for the opinion of 2, my lord, State Pollution Control Board. Will appeal through Bhakal.
item number 33. In the read petition, the Honorable Single Judge has already allowed the read petition in the verbal order. But after that, when the written judgment is formed, it is said that the the read petition is dismissed. And when I said in front of before the court, he said I can say many things inside the courtroom, but my written judgment is final.
When I asked this before the Honorable Single Judge,
This submission you don't make.
item
Please don't make such submissions.
My lord, item 50. So that's why I'm filing this writ appeal.
We'll see.
And the item number 33, originating the lady petitioner is out in justice for 14 years, 18 years. She has disengaged from her job from 2007. And she has filed 3 writ petitions in this honorable court, and all these writ petitions are.
How many days delay?
Is there any delay? There is no delay.
Item 33.
How much delay?
Delay 40 days delay, but actually it is not my fault because the judgment has been published in 31st. 40 days. No, ma'am.
We will see on Tuesday.
My lord, item 50, regarding neat matter may be taken up tomorrow. My lord.
Regarding?
Neat matter, neat revolution.
Tuesday.
My lord.